see you. Just realized that. Yeah. Let me double check that. I'll be right back.
And we have technical difficulties.
We prepared a really excellent PowerPoint. And right now, we are the only two people who can see it, which is less helpful.
I can start, though, by just introducing us. So I'm Susan Guerette, and I've talked to a lot of you on the phone. And as Aggie said, we have a relationship. So if you guys have a basic HR question or something simple, feel free to call us, and we can talk to you a little bit for free and kind of get you started. And hopefully we can often answer your question in that first call. They can hear? Yeah. And this is Michael Galey. So if I'm not available, Michael is also available to talk to you. We both handle HR. We're both part of the education practice group at our firm. So we do a lot of work with schools. This is something we do every day. And just so you know, a lot of the times when I work with you guys, it's on HR issues that we're answering questions, we're talking about leave. But Michael and I actually spend a lot of our time litigating. So we're going to kind of bring that approach to this because when we're not talking to you guys, we're often in court, we're taking depositions, we're defending you guys in depositions, and that's part of the process you probably don't see very much, but the decisions you're making every day really affect how those cases are going to go once we're in litigation. So we're going to kind of bring that approach today so you see how things play out once we actually go to court on the things we've been talking about. Anything you want to add before we get into it?
No, I'm Michael.
Okay. So we can skip it? Or?
Yeah.
This was supposed to be a really fun clip from Step Brothers. So hopefully.
Susan promised that she would act it out
Yeah.
for us if the clip didn't work.
So sorry, I don't know why it's not playing, but. Okay, so we're going to talk to you. We're going to start out by talking to you about best practices for hiring. And what we did was we met with the PAISBOA'S board, and they kind of talked to us about what issues they're finding, what challenges they have. And so our whole day has kind of revolved around what the board here finds as often seen issues. And so one thing is kind of the hiring process. We're going to talk to you about some of the legal issues, but I really want you guys to jump in because a lot of this is just practical advice. And so if you've had an issue or you have a question, feel free to jump in because other people have had the same thing. So when you hire someone, the first thing you want to do, and again, this is probably obvious, it's not a legal thing, but you want to think about what are you looking for? You know, what type of person are you looking for? What type of degrees do they have to have? What type of experience for the position you're looking for? But I want to mention here, I've worked with a lot of heads this year and even administrators who really thought outside the box and reconfigured their administration. And that's okay to do. So don't look at it like I just have to hire the same spot that I had before. I had a head who changed everything up and really was effective in changing the middle school and having someone lead the middle school and the upper school, and it was a much better process for her school. And we did end up reconfiguring that. So there was a very experienced person who was put in a different position, and that was a challenge because she didn't like it at first, but it did work out in the end. So, you know, I'll just encourage you that we can help you think outside the box and change things up if there's a better plan or position that would help your school. But that's the first step, is figure out who are you looking for, what are you trying to hire.
The whole thing goes black.
And then the next thing is really looking at, okay, now you're going to start the basic phone interview. And how many of you, is that the first thing you do after you get resumes in, phone interviews? Okay, great. And is it you guys doing the phone interviews? Do you do it yourself, or do you have, you know, the head coach do it if they're going to hire? How many people do it themselves? Good. Okay, great. So some tips for that is you really want to come up with questions that you use pretty much standard for all the phone interviews you're going to start with. And the reason for that is you don't want to discriminate. So you want to try to have, you know, kind of a clear picture of what you're looking for and some standard questions just to start you off. That doesn't mean you can't deviate, but you want to have those basic questions to use with all candidates. That should be conducted by a member of the hiring team. And you want to make sure that if you are letting someone else do it, and this is going to kind of be a theme throughout, but if you have, you know, your head coach or, you know, the head of the science department doing the hiring, you want to give them some training because there are a lot of ways that that can go wrong. And so if they don't know what they're doing, you might end up with a problem that you were totally on top of, but they kind of went on the wrong track with. So make sure that you do kind of give them some mentoring if you're going to involve them in those initial talks. And then you want to try to take good notes. So sometimes you can come up with those questions, and as you're going through the phone interviews, just take notes under each question and keep those so that you know what was said and what came up during those discussions. And then you want to select people to bring back to campus for further interviews. Okay, so how many people ask candidates for resumes? Good, okay. And then how many people also have them fill out your employment application? Good, okay. Any idea of the question here? Can you simply take the resume and not do the employment application? Any thoughts on that? Yes. Any thoughts on why you shouldn't just take the resume? Exactly. Yes, exactly. And that's something that sometimes we forget about. We get the resume, we start working with the candidate, and we forget to have them do that application. But that application is really important, exactly for what you said. And you really, after this, you want to take a look at your application and feel free to call me about it because there are certain things you want to have in there. So, for example, you want to have them say that any information they provided is true and correct. And you wouldn't think that's a big deal, but we actually had a school that ended up terminating someone because they found out later that they had not told us about a position they held. And we were able to easily terminate them because we had that in our employment application. So it said right in there that any information you're going to give us is true and accurate. You're attesting to that, and you can be subject to discipline, including termination, if you don't have that in there. So that was great, and it was good that, yes, Aggie?
Can I ask you a question about resumes? So when people do interviews and whatever, should they write notes from the interview on the resume itself?
You can. I don't think there's a
Is there any?
yeah, I don't think there's a best practice. Michael, do you have any thoughts on that?
There's no legal obligation to keep it clean, as long as I can still read the resume, assuming it gets to a litigation standpoint. It's not bad or good. If you have a prepared set of questions, we actually have some clients that have an entire system where position X, you ask questions 1, 7, 18, 30, so they have a whole printed out list of questions, and then they write the notes of the responses with the question. I mean, that's obviously the most useful place to put your notes, but if you don't have that printed out, and probably you should, but if you don't, there's nothing inherently wrong with putting it on a resume.
And is there anything that you should never put in a note about candidates? You know, it's like.
Well, yes. There are a lot of things you should never. You wouldn't want to put in, so-and-so whose race is X, or, had a really thick accent. Think maybe they're from Spain. Anything like that would obviously be problematic. Notes on appearance and things like that, you could see ways in which that would be entirely appropriate. We looked through a bunch of video clips in preparing for this, and there's a scene in the movie The Pursuit of Happiness. It's a Will Smith movie where he comes in for a job interview in a tank top. It would be entirely appropriate to note that the person showed up in a tank top to a job interview, right? You may not want to note if they were wearing a hijab or some sort of religious dress, though, of course. So as we talk through this presentation, we're going to talk about a lot of things that are do's and don'ts with respect to information you're going to see, both in an interview and potentially through online searches. That same type of information is the kind of stuff that you wouldn't want to note. It would be almost impossible for me, if someone sued you for not hiring them and filed a gender discrimination claim, and I wrote something totally inappropriate on my notes. How would I ever argue around that in court that wasn't an aspect of the decision-making process? So I think as we look at some of those questions to avoid talking about, we also want to think, those are also things that you're going to want to avoid making notes on or comments on, or obviously ultimately making decisions based on any of those criteria is going to be a huge problem.
And that all this is discoverable, right?
Yeah,
Yeah,
for sure, absolutely.
So what you might think is just a casual, this is for my own benefit.
Right.
It's not for your own benefit, right?
Yeah, absolutely. Yeah.
I mean, you should always assume that everything that you're writing down for better and worse, is something that is ultimately going to be used in a litigation. The only time that we wouldn't have to produce a document that you've created is if it was something that you specifically created for counsel. Beyond that, anything else is going to be discoverable, assuming it's related to the claim at issue. You keep that in mind, both so that we don't put bad stuff in, and also so that you make sure that you do put the good stuff in. I know that there are a number of points throughout all of our presentations today where we're going to talk about how to document these issues so that if they ever get challenged, we have the tools that we need in that litigation process to say, no, it had nothing to do with your race or gender. It had to do with the fact that you wore a tank top to your interview to be, the head of school. That's not appropriate.
I think I'm good. You answered my
Okay.
Let me make sure you understand too that when Michael's talking about documents, it's not just your notes that day. It's if you get off the interview and I email Michael and say, "God, you wouldn't believe the guy I just talked to." That email is definitely discoverable. And even text now, we're producing text in discovery. So there's nothing that you communicate that we can't, we can refuse to produce in discovery. So just keep that in mind, because sometimes we think, oh, that's casual, that's just between us. But that's completely discoverable, and it's the kind of thing I'm going to pull if there's litigation. I'm going to pull every email you sent about that candidate, any email that someone else pulled or sent to you. So just be very broad about that.
Even the cell phone, when the school's not paid for, you can still get access to it?
Yes. In fact, your school would have an obligation to reach out to you and say, don't delete anything off of your personal cell phone.
In fact, what
In that
I'm going to do is
context.
tell you that I'm going to take your cell phone and I'm going to create an image of it, and I'm going to keep any text messages. So definitely look at that personal cell phone, and we would keep your privacy, but we're definitely going to need to. We're going to have an obligation as the employer to maintain any records even remotely relating to the hire. So definitely. So be very careful. Now, if you don't use your personal cell phone for business, we might have we could then say, well, you don't need to do that. But if you're using it for work business, for school business, yes.
And candidly, there may be times where you get a message and you think, I'm going to save this. You may want to offensively save text messages. For instance, if you had an interview with a candidate, just to keep it in the context of the hiring discussion, if you had an interview and they sent you a text message that was, rude or inappropriate or had all sorts of grammatical or spelling mistakes, and you thought, whoa, this isn't the kind of, quality that we're looking for in terms of interpersonal communication, that would be something that I would hope that you would take a screenshot of, email it to yourself, and throw it in a folder somewhere so that if that person ever came back and said, oh, your decision was unfair, we can say, no, look at this really rude thing you said, or like, you made an inappropriate joke in a text message and I have it.
So good. So just to finish up with the employment application, there are other things you want to put in there too. So one thing you want to say, have them attest to, is that they give you permission to ask any prior employers for reference information, and that they agree that any information that's provided to you, they've waived any liability for that. And that's so that if you do have to check on references, you can assure the other employers that, hey, don't worry, we have this waiver, so he can't sue you or come after you if you give us information. So you want to make sure you're protected and you get true information.
Yes, ma'am.
What about the document that you have to send out for sexual misconduct? Is that?
Yes. So that's the Act 168 documentation, and that gives you the same protection too.
Is that only for the 3 questions then, or for all?
No, so it's just with regard to the information on that. So that's why you want it in your employment application, because you can draft a broader one. And that Act 168 form is very good, but you might want to talk to other people. You might want to ask different questions that are on there. So, yes. Sure. So it should have, first you want to make sure it says that anything they say is accurate and true, and that you can discipline them if it's inaccurate. Then you want to say something and we can send a sample around too if Aggie would like us to. You want to say something like, they authorize you to request information from anyone listed above, and that they waive any liability for those people providing that information to you. So they waive liability for you getting it and for the person providing it, so that there's no question that you can get that. And the last question is, what if you use a service like Carney Sando? We have a lot of great recruiting firms. They are usually good, but you should still rely on your application and make sure yours is filled out, because they might mess up and slip up and not get that, or theirs might not be as good as yours is. So make sure you still get your application. Okay, and I think we covered this. Yes.
Another
I was
question?
just wondering, is the waiver available on the website?
I'm not sure if it's in our library. I can check that afterwards, but if not, we can put one in there. Yeah. And we do have this library of forms. If you guys think of a form that would be useful, we've tried to over the years, we put like field trip forms in there, job descriptions. But if there are things you come up with that you think would be useful, let me know because we can add to it if there's something we're seeing over and over people need to have. Yes.
So, is it necessary to get, say you get the resume, and you want to just speak with
Uh-huh.
and it's really just a screen out who you may want to follow up with. Now, do you get the application after the fact or before the fact of speaking?
You know, there's no right way to do it as long as you make sure you do it. So if you feel like, geez, I talked to 50 people and really only 10 am I going to go through the process with, you can just get the employment application for the 10. But you do want to make sure you have some kind of system so you don't miss it. Yeah. So does anybody have a practice that they follow that would be helpful or? Yes.
We have our folks take the application, if we decide to bring them in for a face-to-face interview.
Oh, good. Okay. That's great. Yeah. Good. As long as you get it for the people who are you're going to pursue, that's the important thing. Okay, and so you might already be doing this, but things to look at on the application, incomplete responses. So, you know, really look at it because this is where employees do hide information. Employment gaps. This is what we had in that case. The teacher actually had been terminated from one of his prior schools, and he kind of passed it off like he had quit because he was taking care of a sick father. But actually, when we found out later was that he had been terminated. So you want to really understand why is there a gap in employment, and then, you know, try to get more information. Yes.
Like the health insurance meeting, we're going to get the full slide deck when we get the slide deck.
Yes, we're happy to give them to Aggie, and I don't know if she wants to post them or put them in the library, but
Put the forms?
the slides, Aggie, do you want to?
Yes, we'll definitely share them.
Okay, good. Yeah. So job hopping, that's just, you know, shows that they're not necessarily committed, career changes, relocation, and that is something you want to look at. You know, why are they coming here? Are they committed to being in this area? See resume. You know, if you're talking to them and you're getting them to fill out your application, you want that in your application too. Because again, the application is going to say everything in here is true and correct. So you don't want them to just refer to the resume. And then reasons for leaving, obviously talk to them about why they left, you know, what happened, and get references. You know, you will have the Act 168 references, but you also want to get personal people that you can talk to. The Act 168 is just a form that's sent out. You want to find out who exactly should I talk to over there.
And it's still Philadelphia that doesn't they ask about criminal convictions.
Yes, and that's one of our
Yeah.
slides. Go ahead.
Yeah. Yes.
It's just everybody else.
Yeah, so what he's talking about is Philadelphia has this unique thing where you can't ask about salary history. There are limitations on when you can ask and how you go about that. And that's the only location right now that has that, but it is something to be aware of because we do. Oh, right, ban the
Ban
box.
the
Okay,
box,
that's a
yeah.
different thing. Yes, there's also that too.
Yeah, the salary
Yeah.
history was
It was shot down.
sort of.
Yeah.
So the court said, you can ask about it because you have a First Amendment right to ask, and we can't prevent you from asking, but you're not allowed to rely on it.
Right.
So I'm sure you can imagine what our advice is going to be. If you're not allowed to rely on it, don't ask about it.
Right.
Exactly.
So, and that's an area we're going to get into in more detail too. Yes. I would still use it, yeah, because you still want to have that ability to fire them if, you know. Keep in mind, you know, that you want to give yourself the most ways and easy ways to terminate people who aren't working out. And so this is just another kind of way to do that. So it's helpful to have.
I tell people, as nerdy as it sounds, as a litigation attorney, there's nothing better than asking your client for documents and getting like 2 banker's boxes full of stuff. That, as soon as I see that, before I've read it, I know that I'm going to have a good case, that our odds of winning this case are going to be good. If I ask you for documents and you send me this, I'm going to say, this is all we have? That's going to make my job a lot more difficult.
Okay, and so then on-campus interviews. So then after you've kind of gone through it and you know who you're going to bring back, you want to have those on-campus interviews set up. And that's where you really have to make sure the training comes into place, because you might be great at this and know exactly what you can and can't say, but that's where we see a lot of problems because our coach asks inappropriate questions. Or emails someone after he, interviews someone and there's something wrong in that email. So you might want to just take the time to have a little bit of a conversation with people who are going to be part of that interview process to make sure everybody's on the same page and kind of knows the do's and don'ts. And then, as Michael said, be careful with comments and yes.
So we talk about this a lot, but one of the questions that come up for us is parent interactions with candidates. So there are certain positions where our parent groups will meet with the candidates and ask questions. So if we're struggling with finding like some guidelines for our parents, would you have any suggestions?
And you do that because you find it helpful to get their input, or, okay.
Yeah, I would assume that the number of positions you'd want to do that for are both limited and relative to high-ranking positions.
And they
right?
are.
Yeah. So if it's a head, you can understand why there would be a broader search. I think the guidelines for them should be the same. And honestly, it may be incumbent upon you to be present at that. And let's say a parent stands up and says, where did you grow up? You have an accent. I appreciate you being here. Thanks for coming. But, those aren't the types of things that, we're going to ask Mr. or Mrs. So-and-so to comment on at this point. You may have to be that person that says, whoa, that's not an appropriate question to ask in this context. Oftentimes people will have already said that, right? But that's just an easy example. So I think the guidelines that you would want to distribute to your parents are no different than the guidelines that you distribute to your employees, because one of the things that becomes important is not just whether or not you've asked, but it's if you know, right? If I don't know that you have a disability or that you're from another country or whatever the case may be, I can't possibly rely on that by not hiring. So once that information's out there, regardless of who solicited it, I have that knowledge, and now they can always say, well, it wasn't until the parent asked me if I suffered from a disability, to be silly a little, that you knew that, and then you didn't hire me, right? So I think the criterion that you would expect from your parents in that situation is going to be similar of what you would expect from your your employees, recognizing that your control in that situation is going to be a lot less.
Just out of curiosity, do you have someone sit in on the interviews with the parents and the candidate, or do you kind of let them do their own thing, or,
Well, we work with bigger schools. A lot of our surgeries, we have surgery committees.
Oh, good, okay.
HR, we try to insert ourselves in the
Right.
as much as we can.
Good.
So a member of the surgery committee usually have to give us any information.
Yeah, I think, or anyone who you believe would do as good of a job as you in managing that, right? It could be, maybe one of your search committees, my daughter goes to a Quaker school, right? I would be the perfect person for you to pull aside and say, like, look, can you just make sure that nobody says anything stupid? Sure, no problem. You don't have to rely only on yourself, but obviously you can trust yourself to know what's relevant and what's not relevant.
It's hard because sometimes they say things and they don't even mean to be doing it. Like they'll write a note that says, oh, I really liked his grandfatherly demeanor. Okay, well now you're looking at an age claim, and they might have thought that was a positive, but we didn't hire him, and then, so that's why it's tough, because you do want to involve your community, but if you can manage it to some degree, it would be helpful. Yes?
What do you think about damage consideration? Say that does happen. What damage would be
Yeah, I mean, in that context, if you've chosen someone for a reason that's not his age or her age, of course, your documentation of that reason, you're going to want to make that the most robustly well-documented denial that you've ever seen, right? Because again, let's say that there are very legitimate reasons for not hiring. We want to make sure that the one page from the parent review that says grandfatherly demeanor it's that versus the 150 pages of pull reviews from parents that have nothing to do with that, or the references that came back poorly. Whatever the case may be, the damage control in that context is making sure that you've justified it, and to the extent that you see a note that says like grandfatherly demeanor, you can always take that out, before you hand it to the group that's making the decision. So if you can sort of isolate that issue from the ultimate decision maker, we're going to talk about that a little bit later in terms of reviewing online content or social media content with respect to the hiring decision. But if you can sort of segregate that information and not pass it along to the people who are going to be making the decision, then you still get the defense that I talked about earlier of, well, nobody gave me that note.
But now, I want to make sure you understand Michael's distinction, because like you don't want to destroy evidence.
Oh, yeah.
So like,
don't throw it away.
Once that,
Yeah.
but what he's saying is like, if there's a group that's going to make the decision, and they never know that this guy is 68, then you won't have a claim because they didn't even know. So you're taking it out of the decision maker's realm, not, okay, good.
Yeah.
Yeah, at the end of the hire, you go through.
Go home, start a fire in your fireplace.
All right. So yes.
Should you, after you make your decision in hiring your person, should you go through and mark all the other applicant reasons why you did not hire them? Why they weren't chosen over, why say A, B, and G wasn't chosen over candidate A?
That's not a
could
bad
do that,
idea,
yeah.
right? I mean, again,
We have so much to do now.
Yeah.
I was just going to say, as a litigation attorney, I would love that.
Yeah.
Right? I would love you to have a narrative reason for why you chose the person you chose, and one for why you didn't choose the people you didn't choose. The practical reality of that may not be possible, right? But if you've documented those answers to questions during the interview, at least I have that to go back on and
Yeah.
see your note that says, asked why he left his prior job, and response was X. Response was, my boss didn't really get along with me.
I mean, hopefully
Okay,
it's
that's
going
a
to be in
red
the
flag,
notes.
right?
Yeah, hopefully it's going to be in the notes, but you're right. If it's not, that would be nice.
Yes?
Yeah.
How do you feel about someone calling all the people that are not selected for a position and thanking them for coming, but then also explaining why they were hired and what their ideas are?
I think the first part is a good idea. I think the second part is a bad idea, right? It's
Say that again so everybody can.
Yeah. Because it's a really bad idea.
the question was, what do you feel about people calling the candidates that weren't selected, telling them they weren't selected, and then explaining why? I don't see any reason why you can't call them and say, thank you so much for your interest in X school. We've chosen to go with another candidate, but we really appreciated meeting you. The end, right? That's a nice thing to do. That may be a perfectly well-qualified teacher that you want to apply for other positions in the future. You don't want to alienate that person. But calling them and saying, that one question I asked you was just not, you didn't answer that well, and this other person is like way smarter than you.
You have no idea what you're saying.
Exactly,
Yeah.
yeah. So if you're going to do that, and I don't see any reason not to, the script should be very limited.
As lawyers, too, we wouldn't want you to pin down your answer in that conversation by saying we didn't hire you because of X, because if they sued you and we got the file, there might be X, Y, and Z. And they're going to say, well, they didn't tell me X, Y, and Z. These are fabricated now. So we would rather you not limit yourself in that as well. So.
Can you offer a canned response for when somebody says, could you help me understand what the miss was, or?
Yeah, I mean, I think that's simple enough to just say.
The question, you don't have to say it, but sometimes just the call incites the question of why, from the potential employer.
I mean, I think the response in that context is going to depend on who makes the call, right? If Susan did the interview and I make the call, then I can say, well, I don't know, I wasn't even there. But I don't think you need to say anything more than, we don't get into the particulars of our decision-making process, but I did want to thank you for your application and appreciated your time.
Unfortunately, as lawyers, we would just rather you not elaborate on that because
Yeah.
it's not going to help you at all. So I know you feel bad because you'd like to tell the person what did they do wrong or what could they do differently, but unfortunately, it just is more likely to open the door to something. So, yeah.
Her recommendation, just in the letter.
Oh, that's fine too,
That's
yeah.
great.
That's the full recommendation.
Yeah.
Right.
I mean, it's going to cost you like 40 however many cents, but no, maybe it's 50 now.
I have a question on age, and hiring. When you have drivers, a lot of people get drivers that are over retirement age who want to pick up just a part-time job. And I know that we cannot discriminate based on age, but when someone gets close to 90, what are our options? Can we require physical?
So that's actually, the second part of that question is actually an ADA question, an Americans with Disabilities Act question, and when you can request a medical examination. We are going to talk about that in the next hour, but
Do you mind if we put that off, or?
No, I don't.
Okay. 'cause-
there are certain contexts where you can exclude protected individuals for bona fide reasons. For instance, there was a case a number of years ago where pilots had a forced retirement age. And I think, the logic of that was very similar to the logic of your question. That was permissible in that context. Before doing anything like that, though, we would want to really sit down and have a long conversation about what sparked the discussion, because there may be other things that are happening that are causing you to worry about the safety. There may have been people report, oh, I saw Joe back over, the orange cone. What's going on? That's a performance issue at that point. That's not an age issue or a disability issue, right? So
This is strictly age. I hired someone and, I of course didn't know the age at that point. And he was much younger and he's doing a great job, but I worry about that and what our liability is as a school.
yeah, I'd be more worried about your liability with the driver than your liability if there was an accident. It's not like if there's an accident, there's a legal theory that's, oh yeah, but you let a 90-year-old drive. I mean, obviously you shouldn't do that, right?
I mean, I know it seems crazy, but legally, that's not a problem, He has a regular driver's license,
Yeah,
and,
I just was curious if we would have to take that into consideration after a certain age.
yes.
Cynthia has basically just believes that the interview process will be good. And he or she handles questions privately, and basically it depends on that person's resume. He doesn't believe in standard questions or real documentation, it's just a verbal phone conversation.
Mhm.
So how do you best protect the schools as questions that should be asked versus questions that are asked, etc.?
Could you talk to the head after they do the interview and maybe take some notes yourself about?
You're not there, and they
Oh.
believe in the standard list of questions.
No, but I think to Susan's point, if you went in after the call and
Yeah.
said, how did the call go with candidate X?
Right.
You could document that. Of course, that's a burden on you.
I think it's the perception or the thinking that it's all over the board. This is not a real environment that you're going to be sued over a phone interview. You know what I mean? Like, you're not getting that comfortable feeling like, oh, let's look up the questions you did ask and let me write that down. You know what I mean?
It sounds like
Yeah.
we should go back to the office and source from our colleagues times when phone interviews have led to lawsuits. And then send you an email on that, right?
And I
Um,
totally, I know where you're
Yeah.
coming from, but it's like, this isn't going to happen to us.
Right.
What are the chances of this? Like, you're always a little bit in the door, right?
Mhm.
And it's that mentality, how do you break through that when it's your boss?
I know.
And it's, you're constantly challenged, and, everything goes back to sometimes coming and just that discretionary judgment.
Mm.
The discretionary judgment is the discrimination suit.
Sure.
But that's not a realistic scenario that you get pushback. So how do you best protect yourself and the school and the environment?
I mean, I think just the fact that our national labor and employment law firm has an entire education practice group should suggest to him that there are
Yeah.
issues facing schools that cost the schools a lot of money, right? Because of the liability implications. I don't know how else to get that message across other than to demonstrate that these are claims that we see on a regular basis across our firm and across the industry. You may just have to see one of them and have your "I told you so" moment.
Well, this is just a scenario, too.
Yeah, yeah. Of course, hypothetically speaking. For your friend that asked you that question before you came in.
Right. Yeah.
Yeah.
Yes, Aggie.
Susan, I know that you put together a report for PAISBOA, and I'm wondering if it would be helpful to all of you to hear from PAISBOA about sort of the numbers, the topics, the, litigation cases. I mean, is there, so that you have some stats to bring to your senior leadership? Because I know this is a problem, and I'm sitting here trying to figure out, how can we help you, like, hit them over the head with some numbers that they'll understand, or some information that they'll understand. So, maybe this is something that we can work with you guys and maybe the HR steering committee to see if there's, a state of the state, if you will, state of the HR.
Is there anything you think might convince him or her? Like if we had statistics on how many, job applicant.
A lawsuit,
Yeah, but I mean, there are lawsuits about this all over the country. So would it need to be like one that they know, like, a local school or?
Even just best practices at
Uh-huh.
minimal that, during interviews, et cetera.
Right.
As a result of these cases in claims paid out.
Okay.
Or they're bullets that they don't have to read much, so
Mhm.
it's just like you can forward when you're educating.
Right.
them, and you're just not being an anal person. You want to do things like this,
Mhm.
because this is our requirement.
Yeah.
It's okay to be both.
You
too.
know what we might want to do, Aggie, is Willis. We worked with Willis one year, and they had case studies where they would say what happened. Normally in our cases, like if we settle for you with an employee, it's confidential, so we can't say what the result was. But Willis was able to kind of go through and give examples of when they paid out. So maybe we could even talk to them and get statistics, so you could see like this one we paid out 500,000, this one we paid out 400, because I think that's going to help to show the ramification.
Co-branded the
Yeah.
information, PAISBOA, Willis, and Fisher and Phillips, if we put together
Right.
some sort of, I don't know, piece.
Yeah.
Can I ask another quick question? Do you have EPLI insurance? Employment Practices Liability Insurance?
It's probably part of the package that Willis provides and
Yeah.
our business
Yeah.
insurance.
I bet your insurance adjusters would also enjoy an opportunity to
Talk about
educate
that.
the head so that they're not paying, because they're the ones that, any big dollar verdict, they're the ones that are going to be paying for it. That tends to be another good resource, an insurance adjuster saying, I just spent $800,000 in the last quarter on my schools that have claims similar to this.
And I think it's important that it's not just, because it trickles down to then you have faculty members who are part of the search team that are meeting independently too. The same is a really off-the-cuff kind of conversation as a response to their responses. And it really applies across the board that if this is the kind of perception at the top.
Right.
It's gonna trickle down and it's not good, and you're really exposing, but it's just not really well understood, I think, from the standpoint of understanding the exposure you're putting the school on.
Right.
I mean, there-
Unnecessarily too. Yeah.
And there should be some tailoring of the questions for each candidate, right? Each application is going to have a unique, present a unique set of questions. The issue is really, how do I document that particular conversation? So it's not like I would say to a head, no, here's the list of 7 questions, you can only ask these 7 questions. There are some corporate contexts where that happens, but it's more a function of taking a direct and intentional approach to the interview and not just, hey, I just looked at this 2 seconds ago, tell me about this. And even if it's that, if somebody can write down, asked about last job, person said X, you know, it doesn't have to be a mechanistic approach, but
Should all those notes go into the file? Like, none of the notes even come back to the file. There's nothing,
Mm.
follow up, you don't even know how the decision has been made for that candidate.
yes.
The
And
personnel file is not keeping all that information.
Do you think if you send him a form that said like, hey, how'd the interview go? Please fill out this form, he or she would fill it out? No? Okay.
And Susan, this is not unusual at
Right.
all. Business schools don't want to play this way for the most part.
Mhm.
They're, many of them have been in positions for a long time, or even if they haven't been in a position for a long time, they don't feel like they need to comply with sort of compliance kind of things, like taking notes in a certain way,
Mhm.
or sharing, interview notes or anything like that.
Right.
It's an educational process.
Yeah.
So I don't think that we in our positions can do that, but I think this is something that we need to get to, you know, some other groups like NAIS, to have them
Yeah.
talk to heads about.
And even Advis does training, right? Maybe this could be a topic they could put on there.
Yeah, I think this has to, I think this is a pervasive
Mhm.
thing that really, until somebody really gets into trouble
Right.
and will share that they got into trouble because of it, then I think it's just gonna kind of be this way. But I think what we can do is give you as much as we possibly
Mhm.
can, and you guys can try and cover yourselves in that you give
Okay.
them every opportunity to do the right thing, but then, you know,
Yeah.
at some point, there's nothing you can do.
Right.
And I think from a subordinate position, it's really hard because you know what the right thing to do is and you feel
Mm.
the pressure of that compliance, but when your
Yeah.
superior will not comply, then really you have to just sort of say it once and be done with it after
Right.
that, or else you're gonna lose your job.
I think we should skip this, but go ahead.
I just want to piggyback on what Ellen was saying. I think her mindset is, oh, that's nothing.
Hmm.
And I think that some kind of a document like that would be really helpful. to
Yeah.
say, oh, yes, it does.
Right. Yeah.
Religious schools. and
Right.
Secular, and there's just a mindset that not here.
Yeah.
doesn't happen here.
Okay.
And, so there's really impact.
Right. So maybe we could put together something that gives some examples of when this has come up for schools, maybe what the result has been, and maybe some bullet points on. I mean, it's not hard. All you're looking for is that they don't ask certain questions. You know, they can still ask their creative questions, but just not to certain topics. And then, you know, document. And that could just be handing you their notes at the end. So maybe we could put something together like that.
you mean,
Mm. Uh-huh. Mm. Right.
And it's like, they're already have a problem, who do you talk to? I don't know.
Yeah.
Like, it's this kind of stuff that I think really starting at the top,
Mm.
as far as here's the bare minimum you need to do to protect the student.
Right.
It's very, very important, and I think as the subordinates, you're just a nuisance, so go away, I don't want to do this.
Right.
And you're like, but that is saying, like, hey, it's done, like, I
Yeah.
advocate it, try to do it, but it's usually dismissed.
Yeah. Well, maybe we could even put together like a memo you could either hand to them or send to them, so you'd be like, look, I at least told you, you know.
and I think
But-
it's important to keep in mind that documentation doesn't have to be formal, right? You know, the bigger companies get, the more formal their documentation gets, right? Like Susan and I get a specific form every time we interview a candidate that we have to fill out. But that doesn't necessarily need to be the answer. And you can convey to the heads that you don't have to, I'm not asking you to type out a
Right.
verbatim report on what you discussed.
Yeah.
But if you took, you know, 17 words of notes, tear that piece of paper out of the
Yeah.
thing and hand it to me. Like,
Right.
that is not that hard. Or send me an email. Email's a great tool for documentation because it's always either in our pockets or in front of our faces, and it saves itself. I mean, it's a really useful tool. It doesn't have to be some sort of formalized report. It can be an email, 10 things on a note. There are plenty of cases where a note on a piece of lined paper has been a critical piece of evidence, even if it was one sentence.
I don't think it's that, I just don't think they wanna, like, put that out, like, it's more like
That's a good idea.
Hey, copy it, yeah.
You are within the guideline for down the road, it doesn't have some.
Right.
But it also shows the donor due diligence.
Right. Yes.
So what typically we started doing was, we'll take a position, we'll look at the characteristics that we're looking for, both in education and experience, and then we'll gear all the questions around those criteria. And then what I do for the hiring team is I'll send out a survey afterwards and specifically have those questions. Did that person meet that criteria? Put a range in there, and then put any feedback on why you think that they did not meet that criteria.
That's a great way to do it. Yeah, that's a great way. I mean, you have to get people who are going to respond to it, but that's great.
Yeah, we don't have any problem with that.
Yeah.
Everybody wants to have their feedback on what they thought about the candidate and why. But the only issue that I get a little bit anxious about is the full day piece. And we try to narrow that down really what we're looking for.
Oh, good.
But that can get sticky.
Yeah. I could see that. Yeah. Okay, great. Yes.
The thing that's frustrating to me though, you can do it all right, and if you have a claim, the insurance company, the first thing they're gonna do is force you to settle, and all this documentation is for naught.
Well-
I'm surprised you guys even have jobs, because even when you're right, they just make you settle, and you're like, if you're gonna go to take it to court, you're gonna be liable for like 90% of legal fees, and you're never gonna take that risk. You're gonna settle for $11,000 and walk up and let them deal with it.
But here's the point. The settlement at $11,000 is one of the cheaper settlements that we see. There are settlements where you add a zero to that, you know? That's actually what your documentation is ultimately buying in most cases.
But you're
And-
settling, and the insurance company's paying for it. I mean, does the documentation ever come into play?
Oh, absolutely. Yes.
Because what's happening behind the scenes is we're talking to the insurance company a lot more than I would like.
Yeah. And a lot more than you ever know. I mean,
Yes.
we're giving them reports. They have
We have, like-
quarterly or sometimes monthly
So it's
reports.
something look likelihood of-
Yes.
Oh,
and
absolutely.
I have to fill out like a case budget, a case assessment, an assessment on the potential for liability. And all of that takes into account, this is a really strong case. We have documentation that demonstrates A, B, C, and D. We think a settlement value at this stage of the case is X. You know, all of that's happening behind the scenes. So I don't want you to feel like that is not useful. The second I get that, that goes into my report, and the insurance company uses that, and the other side knows about that. So that affects the plaintiff's settlement value as well. And that's why you see a settlement for $10,000 as opposed to $100.
Now, the insurance company will often sign a letter, so you can't necessarily use the way you want to use.
You can actually write that into most policies, but that's another issue.
Yeah, when you
Yeah.
renegotiate policies, you can always say, we want to use X firm.
And we do have some insurance companies that we work for that say, look, we're not going to just pay out these claims because it generates more claims. So we don't want to encourage this. So we're going to fight these, even if we pay a little bit more in litigation costs. And so that helps us do that. We don't have that option if you have nothing to hand us.
And the other thing is your insurance starts to go up when you have to.
Right.
Because you're not your policy.
Yeah.
And oftentimes too, that documentation starts affecting the valuation of the case in the administrative process, right? So I'm sure most of you are aware that if you're going to file a discrimination claim, generally speaking, you have to go through the EEOC. That's when we file a position statement. And you know, I filed position statements that were 3 pages long with 1 page of with 1 page of exhibits, and I've filed them that are 12 pages long with 107 pages of exhibits, right? And you can imagine the settlement value of those 2 cases when we get to the court. That all starts affecting both our evaluation of the case and the plaintiffs, because they see all of that information. So when they start seeing that you have that documentation, their lawyers'
Exactly.
numbers are going down.
Because like that position statement's the first step, but when Michael sends that answer back that has your document that says you have no case, basically, this plaintiff's lawyer's not going to want to spend a lot of time then filing the complaint and pursuing it. They might, but because they want that nuisance value amount that you just talked about. But sometimes we don't see the complaint ever. So,
Have we convinced you yet?
Yeah, it's no, I think it's very frustrating to have.
Yeah.
And to have it feel like you are justified what happened.
Oh, it's frustrating for us to
Oh,
work
it
with
is.
insurance
Yeah.
companies as well, because we want to go and say, no, we're going to win this. Like, we have all this great documentation. We're going to put this in front of the
No
court,
board will take that risk.
and the court is going to throw this out on summary judgment. We can't guarantee that, but we love this case. And the insurance company says, that's nice, see if they'll take it.
Yeah. That's true. So should we skip this? 'Cause
Sure.
Okay.
So we've covered a lot of things jumping around. In the interview context, I want you to think like a lawyer at times. And what do I mean by that is, when lawyers take depositions, we ask open-ended questions. Why? Because we want the person we're deposing to do all the talking. The same should be true in the interview process. You want to be doing all the listening and letting them do all the talking. You hear things like, why did you leave your prior company? Well, it wasn't a good fit. The next question should be, why not, right? Let them explain that, because there are good reasons for that answer that would suggest to you, okay, this person is actually thinking about the position and this makes sense. Or they're, like I said earlier, oh, my manager and I just didn't get along. Well, that's a huge red flag. What do you mean by that? We've had answers like that in interviews that I've had for people to come work with us, and it's like, okay, I think we're done here. If that's the best explanation for why you want to come work with us is that you and your old boss don't get along, I don't have a ton of hope for our relationship. So as we talked, the appropriate questions are going to be targeted to the position, the school's culture and mission. It's perfectly appropriate to use hypotheticals if you want to sort of see how they would handle situations on the fly. We've also talked about this throughout the process, but obviously we don't want to ask any questions that are going to solicit information or suggest that we're considering aspects of the person that are protected from our consideration.
And does everybody understand that? Because every time I get a call where we're going to terminate someone, we always have the discussion, remember, you can terminate them for any reason or no reason, just not a protected reason. And so keep those same things in mind with hiring. So you cannot hire people for many reasons, but just not because of those protected classes. So that's kind of what those questions are around.
And the first bullet point's important, I think, to focus on, because it points out that you can't go and get this information in a sneaky way and pretend like it's okay. Well, I didn't ask their age. Well, if you asked what year they graduated from high school, you can estimate their age, give or take a year, right? You can't be sneaky and get that information and say, but I never asked about the age. The same's true with any of these other categories. If you're asking questions designed to elicit that information, even if you're not explicitly saying, how old are you, that's still going to be a problem.
So can you ask them on an application?
I wouldn't suggest that you do, no.
But you can't ask, what year did you attend high school? What year did you attend?
Oh, you can ask that, but there would be no necessary reason to have that information. Now, in the context of a job applicant, you're likely to figure that information out anyway, right? They're going to tell you their work history. But if you have someone that's been teaching for 20 years, their resume may only have the last 10 years, right? And they may say, I graduated from Villanova University with a bachelor's in education, and leave it at that. At that point, you may not have the information to know whether that person's 35, 45, or 55. That's a situation where there would be no reason for you to solicit that. A lot of people put, Franklin and Marshall class of 2004, right? If they've given you the information, so be it. You know it at that point. It's more about soliciting things that you don't already have, because there's no need for that at that point.
I have a question.
Yes, ma'am.
How does social media play into hiring? Like, looking at persons coming in and checking Facebook?
I think that's going to be one of your next slides.
Yeah, we have 40
That's
seconds
what
to, do you want me to just skip to that?
Sure, right? I don't know what's next.
We have background checks.
Well, I have a question about the do not ask questions as it pertains to the family because of our benefits around tuition remission, your kids attending school. Could you speak to that?
So again, that's a situation where, if I was applying for a job at your school, I would say, I have a 6-year-old, tell me about, her ability to go to your school. I've offered that information in that context. That's a different situation than if I come in and you say, so, you have any kids? Are you planning to have kids? How many kids do you think you're going to have? And you can even feel the difference in the way I just gave the example, especially if you're dealing, unfortunately, with a female applicant. That's a loaded question. And there are some people that ask that because they're curious and they're nice and they're like, oh, I have 3 kids, I love it, it's great, you're gonna have so much fun. And there are other people that are asking that information and thinking, oh my gosh, that's like 9 months of FMLA, and if they have 3 kids, you know. And that's why we avoid soliciting that information, because once we've asked for it, you know, if you've asked me about my plans for a family, I'm always gonna be able to say, they relied on that. And why do I know that? Because they specifically asked me about it. That's one of the things that they wanted to know. Whereas if I came in and said it, and I said, well, they relied on the fact that I had a 6-year-old, it's like, we didn't even ask about that. It's like the first thing he said. You know, that's a totally different case.
When it would come to termination, could things like family prohibiting them to be at work or pulling them away from work, if those things play into termination? You know,
Yeah, I mean, that's a context-specific problem, because there are times where absences related to family members would be protected, such as under the FMLA, if your family member has a serious health condition, you get protected leave for that, right? So terminating an employee who couldn't come to work in that context would be a violation of federal law. However, terminating an employee who is missing work because they just, you know, can't get it together is a totally different story, and there's nothing inherently wrong with that. It's if there are other protected reasons for them missing work that you would really want to consider your response. So we had the question about internet searches. I think I'll just stick to this slide on that topic, which is if you're going to do internet searches, and there's nothing inherently wrong with it, apart from the fact that you may learn things you wouldn't have otherwise known, we would suggest you designate somebody to do that. You know, especially if you can designate someone who's not an ultimate decision maker. And that person can look through the Facebook account or whatever it is and say, all right, is there anything in here that's really relevant to our decision making? And as they look through it, if they see things that are, you know, normal posts, great. Obviously, if you saw something like happy 4th day of Hanukkah, I'm not sure. And you were like, oh, look, they're celebrating Hanukkah. That's the problem that we're trying to avoid here, right? So designate someone to look at it. That person should then filter up the chain anything that they see that is problematic that would be related to the job that they're being hired for, right?
So does that make sense? So you're protecting yourself because they're hopefully going to give you just the information that's in there that's related to the job. You know, if they see the person's pregnant in a Facebook picture, they're not going to tell anyone who's on the hiring decision-making about that information. So you can say, hey, that might have been the case, but we didn't even know when we selected the person or chose not to.
Yes.
You would let the candidates know that we're doing that, right?
I wouldn't.
Okay, so we don't have to.
No, there's no
No.
legal requirement. That's public information.
You obviously shouldn't do anything inappropriate to access it. I wouldn't go to, you know, if you have a colleague who's a friend of the applicant, I wouldn't go to them and say like, hey, Susan, you're friends with Bob,
Yeah.
right? Could you just log into his Facebook account or your Facebook account and show me what, you know, I wouldn't do that. But
You can't
if
make
it's
them
publicly
know
out
you're-
there,
yeah.
there's no reason you would have to tell them that you're looking at it.
so what would you advise folks on that to go moving from there?
Well, that's sort of up to you. Like I said, there's nothing inherently wrong with it if you do it in a way that it's separate and apart from the decision-making process, right? So if Susan's the person that's doing the hiring and I just work there, it's fine for me to see that because I'm never going to be involved in the decision-making process. And if I don't tell Susan that the applicant's pregnant, she can't demonstrate that it was pregnancy discrimination that resulted in her not being hired, right? Now, I'm going to spend several hours doing this. So from an operational perspective, it may not be worth it. Most people these days, you would hope, are smart enough to have it set on private. In fact, if it's not set on private, that may be a problem just in and of itself, right? Like, I don't know about this person's judgment. But no, there's nothing inherently wrong with doing that. That's a matter of your own preference, as long as you're making sure that the people who are making the decision aren't being shown information that's irrelevant to that decision-making process. Yes, ma'am.
Now, because of course there's millions of people on Facebook, Twitter, LinkedIn with the same names. Say you pull the wrong person, pass on that information. Then what? I mean, if you say, oh, this person's that, this is all that they've done. And you may not have a picture could be 30 years old, and you pretty much pass it on to those making the decision, and it turns out that it's not the right person. Like, how do you address that, or do you address it, or what do you do?
Well, you'll probably experience some feelings of guilt, but apart from that, there would be no real legal issue in that context because the law is going to say it's against the law to discriminate. It's not against the law to make mistakes, right? And as long as if you thought that person had posted about like, we got so wasted and went and stole things off this golf course, if you saw that posting and said, no, we're not hiring him for that, and it turned out that actually that wasn't the right guy, there's nothing illegal about that. So, you may feel bad that it happened, and you may want to take steps to say, oh, I'm sorry, we excluded you. Can you come in for an interview? But you haven't broken any laws, actually, by making a mistake in that context.
I have to say, too, just to add that practically the internet and Facebook is becoming such a big part of all of our cases. You wouldn't believe how crazy it is. Like, we have a case right now where someone brought a discrimination claim against another employee, and one of the things they're mentioning is that on the employee's Facebook page, he has a picture of his son's dorm room, and there's a Confederate flag in the background. And we're going to have to explain that that's not even the son's flag, it's his roommates, and his roommates actually, against that, but it's just putting it up in like, I don't know. But I mean, isn't that crazy that a Facebook post of the employee's son's dorm room is mentioned in a complaint? And we're going to explain that because that's part of what the basis is. They're saying to show that this guy has a discriminatory attitude, that this is what his son has in his dorm room. So I mean, that's the kind of thing we're seeing a lot of. And your parents, unfortunately, are going to probably Google some of these teachers, Every time some of our schools get a new teacher, we hear from the parents. And we've had teachers fired because, they have a picture of themselves in a band and they're wearing like a T-shirt with, pot insignia on it, That's not protected, and the parents see that and they don't want to, someone teaching their kids who has that kind of attitude about drugs. So unfortunately, like, even though you feel like it's invasive, it's becoming a big part of our litigation on all aspects of cases.
I'm okay with Google or LinkedIn, but Facebook doesn't do much.
I know. Yeah.
Crossing the line.
Well, that's why you should set it on private.
Yeah, and we say to our employees, we always recommend that you guys tell your employees, hey, make those things private, don't friend with parents, don't friend with former students. And I know we get pushback on that, but it's for their benefit. It's, yeah.
The thing that's getting me though so much recently are these high profile, this Kevin Hart thing with the Academy Awards. I know it's not a job, but it is a job. I mean, he accepts the Academy Awards to be the host, and 2 days later he gets off because of some postings he did 7 years ago. And the Academy Awards, whatever that group is, didn't look into that stuff. An off-color comedian picked for a certain reason, and now 48 hours later they have to have school. A high-profile thing like that and a staff member of a school, I don't, how are you spending all this time on these hirings in a small school and things like this happen? Where's the protocol in all this? I don't get it.
Well, and it's up to you. We're not saying you have to go on Facebook. You don't have to check it.
Right.
I'm just kind of telling you practically that, I get calls from school saying we just hired someone and the parents are making us think about it. So I just want you to kind of have the heads up.
Yeah,
But
is there a, these postings for this individual were 5 years ago?
yeah, no, there's no cutoff. I mean,
Right, and nothing
yeah.
shows since then. So is there ever a
No.
point where, okay, I've grown up and
no. I mean, I
Well,
know
I
it's
mean,
crazy and frustrating, but
Yeah,
Yeah.
that's what I was going to say. I mean, the Academy always could have said, look, we understand that these jokes are inappropriate. They were made 7 years ago, and we stand by our decision. I mean, that's their decision to make in that context. The same way you could say that to a parent that says, look at this Twitter feed from 2012. You could say, yeah, no, I understand that shouldn't be there. We've notified the teacher about that. It's been deleted, but we think that he or she is a much different person now. You could always say that.
You guys are just in such a unique situation because you have parents and they can just walk. And so even though you could explain to them, oh, this guy, you know, is not representative, we just want to protect your employees by not even giving them access to that, because you have parents who can be like, I don't care, I'm not going to let this kid teach my kid. And then what do? You know, you're going to lose tuition, or you're going to just get a new science teacher, you know?
Which is exactly why, you know, we say that you should say, make all of this private.
Yeah.
Don't be friends with parents. Don't be friends with students, because once you've given them that access, and they go through it and find the pictures that they don't like or the things that they don't like, you know, you're going to come back and complain to me that we're firing you, and I'm going to say, I told you not to. I told you not to be friends with Steven's parents or whatever. Sure. What do you want to hit?
Okay.
Skip all the.
Okay. Okay.
Going to do background checks real quick?
Yes. We were thinking maybe we'd go through this stuff in 5 minutes and see if there's anything you guys want to talk about more extensively, and then we'll take a break and we can even talk about that stuff while you're eating. Okay. So job offers, just make sure if you send out any letter, and stop me if you want, I'm going to try to go through some of this quickly because we have so many topics, but make sure your offer letters are conditional. You know, they have to make sure they pass their background checks, that reference history clearance, your educational checks, so just don't make an offer letter, because if they accept it, you have a contract. So I think you guys know this, but Pennsylvania has clearance requirements. You need to make sure that everybody gets these clearances before they're hired. We've gone through this extensively. If you have questions, just feel free to call or email me afterwards. This is one of the most challenging parts, I think, of your jobs. I don't know how you do it, because you do these background checks, and then you get these police reports, and I get so many questions on how to read them. And I have to tell you, I have to look myself, because you have to go through, and I can give you the statute if you ever want it. You have to look to see, okay, is it a felony or a misdemeanor? And then if it is, does it fit into one of the categories where you can't hire? Then if it doesn't fit into one of those, how long ago has it been? Is it 10 years, 5 years, 3 years? So this is a really challenging aspect. And we had the police even one time come in to talk to you guys, and they were like, yeah, these are hard to read. So, you know, feel free to call me if you have questions, if you see something come up on there that you're not sure if it kicks them out of the job.
Real quick, background check.
Sure.
When did they expire? In terms of expiration, those 5 years.
Uh-huh.
But let's say child abuse is one, September, criminals, October, and the fingerprints, November.
Uh-huh.
Do I tell them to redo them all in September?
Yes, I would. Yes. Yep. Yeah. Okay, so I think we've covered this. So you do have to be very careful, you know, what you cut out. Do you want to, this is kind of your topic about whether. So certain things you just can't hire them for, and that's your, you know, what you come up with in the background checks.
So in considering, yes.
I've had issues where we got fingerprinting and somebody had their records expunged. So what do you do in that case? You get rid of the one you saw before and hang on to the new clean one? Or you
Yeah,
keep it all?
yeah. If it's been expunged, then it's like it never happened. So they can get a pass on that, which is good sometimes.
But in terms of the record stuff?
I don't think there's anything wrong with keeping both, but make sure you keep the one where it's expunged, because you want to be able to show this is why we kept the person. Yeah. Yes. There is a provisional employment section, so you could go through it. You'd have to go through and make sure that you're meeting that, though. And I'm happy to talk to you afterwards, because you might need to make sure you're still having them supervised by someone, you know, they've submitted the forms and they can attest that there's not a problem. But there is a provisional process that you could follow. Yeah. Yes.
Do I have to get brand new clearances for a new hire, or they be maybe less than a year old when they start? For their criminal background check and their child abuse and their fingerprints?
So you're saying like they were with another school and they're less than a year old. I believe those can transfer. Yeah.
So
Any other questions on those? Or? And again, I'm happy to talk later. We just want to get through some of this stuff, and it's a lot of material.
here's my 60-second presentation on considering criminal backgrounds. In Philadelphia, you're not allowed to even ask about it. Under Pennsylvania state law, you should only consider felonies and misdemeanors to the extent that they relate to the job that the employee that you're hiring or potentially hiring. What I mean by that is, if somebody has a DUI and you're hiring them to be a math teacher, that may not be relevant to that job. If you're hiring them to be a bus driver, that may very well be relevant, right? Yes, ma'am. It may be relevant in that context, right? But it has to be relevant to the job that you're hiring the person for. You also have to take into account, so the EEOC has taken the position that you really should only consider criminal backgrounds in the same way that the Pennsylvania law kind of outlines, meaning if it's related to the position. And they also talk about the things that you're supposed to look at. Now, this is not something that's necessarily, so there's no federal law that says this. This is the EEOC's interpretation of Title VII. And their position is essentially that criminal backgrounds are inherently discriminatory, both on racial and gender lines. As such, we're going to treat them that if you're considering that, you have to have a really good reason for it. And you need to look at the nature and gravity of the offense. So if the person got a DUI when he was 21 and you're going to hire him to be a math teacher at 38, that doesn't, and you call me, I'm going to say that is not an offense that you should disqualify this person for. Even if it's a boarding school teacher and it may be related, it's so old. The person's been teaching for 15 years without incident, right? We're not going to consider that. These are the factors that you're going to want to look at, even if it's related to the job. You're going to want to consider the nature of the offense, the time that's passed, and other aspects. Has there been increased education since then? Have they done other things to demonstrate that they're an upstanding member of society before you use that conviction to disqualify the candidate? This is obviously setting aside all of the things that Susan was referencing earlier. Those are automatically disqualifying under state law. I'm talking about other things that wouldn't fall within that category, but that you may still want to consider. Should we break for lunch?
Let's see what else there is. So, okay, I think we've covered most of this in a nutshell. So Act 168, those are the history forms you're sending out. So you want to send those out to everybody that they list, and they should give you separate forms for. Is everybody familiar with this? I don't want to. Okay, good. Okay, I'm sure you guys are already doing this. Okay, and then you do want to check their education, confirm they have the degrees, especially if it's a very developed or important job. And then health forms. And I just want to point out with health forms, you do need to get the health forms. There's a certain health form you're supposed to be using. If you don't have that, let me know, because I do know a lot of schools are using different forms, and there's one that you're supposed to use. And that information should be kept separate and confidential.
Can I send that out to everybody?
Sure, I can send it to Aggie.
Is that for all employees?
Yes. Well, yes.
Everyone that works in school?
I believe so. I'll look at the statute, but I can't think of any exception. Is it
We don't have health insurance.
seasonal? I'd have to check on seasonal. I mean, I know it's going to be all your grounds people and your transportation people, so there might be exceptions for substitutes and things like that. But really, they actually take this very seriously because they want to try to control disease. So they want to make sure everybody's got tuberculosis and all those things. So, okay. Okay, great. So I think that's it for this section. And I'm sorry to go through it quickly at the end, but we have 4 more topics we want to hit, and we want you to get lunch. So we're around, and we're happy to talk about any of these topics on the break now. And then we'll start with mental health when we get back. Is that okay?
Yeah, that's fine.
Okay. I don't want to short circuit, but we had so much to cover. That was an hour and a half. Really, whenever because we can get started. If they want to have like 10 minutes, we can then get started at like 35 after, or whatever you guys want.
What are the other 4 topics you're doing?
Mental health, sexual abuse reporting, social media, and compensation issues. What we told Aggie was that if we don't get through it, we can do a webinar maybe in January on the topics we would hit.
This compensation is in it, right?
We were going to actually go through kind of, and then yeah, this is their steering committee came up with this topic.
but they're paid like a 1099. I do have a contract with them, but what I'm not sure is, should I treat them as if they are, like Heidi make them all good, any of that kind of stuff, so I did background checks.
So the question is really ultimately going to be, are you properly classified? What the state is going to do, level of control over your daily lives and your daily work. I think it sounds like you have an expectation of treating them as that person's probably better classified after. If you want to talk about that we may want to set up a time that we can have a phone and go through more explicitly what where the lessons happen, all of the stuff that relates to that person's job. And if those answers start to come back, then I think what I would say is they're
Hi, how are you? I really appreciate you asking questions. That's great. Yeah. Oh, wonderful. Yeah. That's such a great school. So.
Yeah, it's good. It's good. But, a lot of issues here.
I feel like Barbie level, yeah.
And I just feel there's a lot of
within so he couldn't show up tomorrow. So he has to come in and teach to the extent that that's I think that's something to look into.
I know. Right, exactly. They'll finish our gigs.
Yeah.
What would change is then I have to be responsible for all the legal taxes. So.
And workers' compensation. But think about it from the other side, which is if something happens, there are a lot of ways to make it fire when you're
You know, don't want to take the rest, and that's what it's actually after on 60, I know it's taken off.
That's actually probably
because
you're treating them like a so if you look at that.
I want to really
because what I didn't do is I didn't read out. I gave them a contract.
oh my goodness, you're out, huh? Right.
That's why I'm just getting some. The problem is it's a new concept as a like, oh, maybe it's cheaper actually to have them contract, and then I'm wondering, maybe it's too really beneficial to have them. Like they can still work 5 to 10 hours a week.
whatever their race works out to be.
We do all kinds of
So they still have to make that as well as rating. They're getting $30 an hour on taxes.
Yeah, we have discounts for businesses, so, happy to,
I might have to. Yeah, I mean, I have, yeah, I gave my 10 people
so if you want to see now, we just talk about HR hiring process.
That's,
I'm
you
having
never,
a
making an
lot of
employee
that,
never.
I do a lot of,
Assuming you do all the things
child
correctly.
abuse records. We do a lot of like boundary issues, probably between employees, but we do training. That's great.
Both state and federal.
Right. For HR too.
There are serious probably worth figuring out, but it does sound just on the surface that this is something
Well, that's right. I kind of have a
Seems like you have a little,
I jumped into starting the school, you know, feeling like some changes, like I took one teacher and made him the principal, but he's still serving as a contractor.
that's a lot of faith. You're taking that. So I know we want to go back and think about it. Once you change it, there'll be a lot of work to change. Once you make the change, it should be a relatively simple process to manage.
My now was something because I don't really have that.
Well, yeah, not only that, but think about all of the
No, I got all that. I started in school, but it's just that. Yes, because I said, if they're not, they don't have to pay for it, so I,
again,
you know, so they're, right.
makes it
Totally get it. Something's telling me. I just needed
Yeah, we're trying to,
yeah, they didn't know me. So I was,
well, it's like one of those things, you know, your instinct is bothering you. I know,
like I have one guy who actually but it was all like this. Can we ask, well, are you Christian or certainly in the community,
all of that stuff falls into like that. To allow them.
Right, I know, it's in the purpose. It's just like, what church you go to, you
And it's they just came in and did their like service, but here I hired three, right? But I'm sure official practice is I got this horse and I'm like, feeling like they all have that. The other thing I need to look into is, you know, I don't know, like, how you ask them, what's your and I have no idea, but there is theological differences.
I
I want to talk about some of these.
Again, probably all one laws. Even if it's written that you're going.
The only thing is,
Okay, so I'm getting,
it was just kind of.
all right, I'm getting an email about this section, what you're and you would have like an interview.
Yeah, we usually have
Okay.
and then we give it to you. And we usually try to make it so it's almost like a step-by-step guide. So, you know, be like this one, where you can tell. I really need points for.
Yeah, I think that's.
That we could put together like a little handout for you. So, some of us have prepared, but I do like to see it.
Right.
Yeah, we do a lot of things. That's very common.
Okay. Wonderful. Thank you so much.
Okay, cool.
Do you think, I don't think I have that up right.
I did.
Oh, you did? Oh, good, awesome.
I don't know why it's in that weird little view though. It's up on the screen.
Do you think we can change it though? Should I click on it? I don't want to mess it up, but I kind of need to see it bigger than that. Should I click on it? Nope, that didn't do it. How about this? Nope. How about, nope. I don't know.
I took the cover off my water so we can keep them straight.
Oh, good, okay.
Yeah, no.
How about, could we close the notes thing? No? That's really weird.
That's helpful.
How about with this thing?
Here we go.
Oh, good, good. You got it. Awesome.
Oh, wait. But now it's not on the thing.
So now use your discretion because, like, we have some sides at the beginning. Maybe we want to be quick because this is like once we get to their questions, it like.
Here we go. That's the best
Okay, now
I
you're
can
being
do.
fancy.
Well, that's the best I can do because when I hit the presenter view, it went away up there.
Oh, funny.
So now I got it back up there.
Our perplexed looks.
It came up like this, and I'm like, that's not big enough.
Trying to resize it.
Yeah.
Is
So
that the best way to do it?
can I just do
If you
this?
want to keep the notes up,
Oh, I don't think we have notes.
I don't have any notes in.
then you
not in
can
the
just
slide.
do it.
Maybe this.
If you just do duplicate slideshow, and then if you don't have like notes on
Uh-huh.
it,
No,
you
we don't.
Really,
Okay.
That'll just give you the slides without that interface.
Okay,
Cool.
and that'll let us go through them. Oh, perfect.
Same
perfect.
thing. It's just without that like black.
Okay.
It's all stretched
Awesome.
out.
Yeah, that's fancy.
Makes me feel like I've been drinking.
Okay, thank you. Okay, so we get started? Okay. So we're going to get started because we want to get through some of these topics with you, but feel free to keep eating. We just want to kind of make a few announcements. The first thing is, just so you guys know, the HR arrangement we have with PAISBOA is that you can call us for simple HR advice for free. And you can call me, on Monday and then call me again on Friday. So it's not just a one-time-a-year thing. It's simple HR advice. So, if you're going to terminate someone, we have to talk 5 times about it, then it's not going to be part of the relationship. But if you want to know, geez, I have this person going out on leave, how much time do I have to give them, or when does it start, or, this is what we're thinking about doing with a new position, it should be exempt or non-exempt, those kinds of things we can answer for you for free. And sometimes it might, get you where you need to go for the next step. We also have an HR library, and that's something you can get through Ron. You should have your own school sign-in. And it does have job descriptions, certain forms. We just put recently field trip forms on there. And if you think of things that you need, feel free to email me. Sometimes we might have that form and I can not only share it with you, but I can put it up there. So we're happy to add things to the library as we see things you guys need. And the last thing we wanted to mention is that while you may have insurance, if you have a certain lawyer, and obviously we would love to work with you, you can always write that into your policy. So don't feel like you have to use the insurance company's lawyer, but you need to write Fisher and Phillips in, or if you have another law firm you're working with, when you get your insurance, you can write that in there. Most insurance companies will let you do that. We work with at least 12 insurance companies, so law firms are used to working with insurance companies, and they're used to you writing it in. So then we're going to turn it over to the next topic.
Alrighty, we are going to talk about mental health issues and how that relates to the ADA, and then somewhat the FMLA. This is a topic that is exceptionally complicated and detailed, and we could frankly stand here and talk about it until next Tuesday and probably not exhaust it all. That shouldn't dissuade you from stopping me and asking questions. I thought the last session was really great and appreciated all the questions you had. We're focusing on mental health issues for a couple of reasons. Chief among them is that we've seen a gigantic increase in plaintiffs bringing employment-related claims based on mental health issues. The EEOC has issued guidance on this particular topic, and they've seen a dramatic increase in the number of charges alleging discrimination on the basis of mental health issues. Another reason why we want to talk about it is because they are somewhat different than physical disabilities in that there are particular stigma associated with them. And you can even see that in the language that people use around the office. People say things like, oh, that's crazy, you're just being crazy, so-and-so's out of their mind. Those are phrases that people use in everyday conversation that relate to mental health. You don't hear people walking around the office talking about physical disabilities in that same sort of way. It's also not obvious all the time that someone's suffering from a mental disability. Everybody has bad days, right? There may be some days when I don't want to talk to anybody. That doesn't necessarily mean that I am suffering from a mental disability, right? makes it a lot harder for employers to identify those issues. Oh, here it is. Courts and employers struggle with the issues of whether the person is disabled, and we're going to talk about that in a little more depth. When is the interactive process triggered? What are the essential job functions, and can we discipline, terminate an employee with known mental health disability? The answer to the last question is, of course, as long as you're not doing it for that particular reason. We have an obligation to accommodate all employees who are disabled, unless doing so is an undue hardship or a direct threat to health and safety. And we're going to talk a little bit more specifically about what a direct threat is. We'll talk briefly about what an undue hardship is. And keep in mind that accommodations must be reasonable. You know, if someone came to you and said, I have an allergy that's exacerbated by this building, so I would like you to tear down this building and build me a new one. Right? That's not reasonable. That's frankly probably an undue hardship as well. So our obligation is to provide reasonable accommodations. What is a disability? It's a physical or mental impairment, hence our topic today, that substantially limits a major life activity. Mental impairments are any mental or psychological disorder. Limiting a major life activity. Major life activities are very basic things, and it's a very broad category. Standing, walking, lifting, breathing, speaking, anything like that that is it will be considered a major life activity. So if you have a physical or mental condition that affects your life in one of those categories, you suffer from a disability under the ADA. The last bullet point covers what we call regarded as claims. An employee can bring a claim for disability discrimination, for instance, even if they don't actually have a disability, if you were treating them as though they had a disability. So I talked about some of those phrases that people use in the office, like, you know, so-and-so's crazy, so-and-so's out of his or her mind. Those can form the basis of a disability discrimination claim, even if that person doesn't actually suffer from a physical or mental disability, because they can use that as evidence that you were treating them as though they suffered from a physical or mental disability. It's a very sort of convoluted aspect of the Americans with Disabilities Act, but if you treat someone as though they're disabled, they're going to get the benefit of the protection of the ADA. So what do we look at to determine if a condition is a disability? We're going to look at the severity and the nature of the impairment. And then we're going to look at the duration. Generally speaking, conditions that are temporary, short-term conditions without lasting effects are going to be not considered disabilities. And I'll give you an example of one where I've actually had a case on one side and there's case law on the other side. There was a case a couple years ago. A woman, I think it was a woman, broke her ankle, was out for a couple of weeks. The ankle recovered. It was a non-displaced fracture. A couple weeks later, everything was fine, back to normal, no long-term effects. The court said that's not a disability under the ADA. I actually have a case right now where the woman went out on maternity leave, and while she was on maternity leave, she fell down the stairs and broke her ankle. Again, a non-displaced fracture. However, there have been significant and lingering effects from that. That is a much different situation than the last one because the duration of the condition has continued and the effects of that break are now long-term. It's impossible to tell whether they'll be permanent, of course, but there has been a long-term impact. So even something like a broken ankle, you can't just look at it and say, it's a broken bone, you'll be fine, get over it. There are situations in which the effect of that condition can transition it from something that we would consider temporary and not constituting a disability into something that is actually, in fact, a disability upon which the employee can make a claim. So we have a case study. The teacher is diagnosed with depression and attention deficit disorder. She has been seeing her physician for several years and has intermittent periods of depression. However, she recovers after a short leave from work. Her depression has affected her ability to work, sleep, and relate to others. Anybody want to volunteer to answer whether or not she is disabled? Yes. Yes, she is. Probably actually in two different ways. both from depression and attention deficit disorder. Both of those conditions can constitute disabilities under the ADA. What type of accommodations, even from this fact pattern, can we tell that the teacher needs with respect to her disabilities? Or his, I don't know if it says her. Short leaves, exactly. This is actually a pretty simple accommodation case, right? We have to give her some time off when she needs it to mitigate the effects of her depression, and then return her to work following that leave. There's nothing in this fact pattern that suggests an accommodation necessary for the attention deficit disorder, but certainly if presented with a request or an opportunity to accommodate that, you would have to do that as well, and we will talk about that process momentarily. Yes?
With pay or without pay after she uses all the
Leave under the ADA is always without pay, subject to having the employees exhaust their PTO. Same is true under the FMLA. FMLA leave is not paid leave. Again, you would want to have your employee exhaust his or her available PTO. Now, of course, if you have a policy that says otherwise, you would have to follow that. So if you have a policy that says, hey, if you have a leave of absence, we'll pay you for the first 2 weeks of it, obviously follow that. Another hypothetical. Lucy is a schizophrenic. Her condition is very well controlled by medication, and her coworkers have no idea of her diagnosis. Every couple of years, however, Lucy begins struggling with the recurrence of symptoms and has to take time off to get her medication reevaluated. Her illness only impairs her for a few days or weeks every couple years. Does the fact that the medication controls her illness mean that she is not disabled? Correct. Maybe we'll have some harder ones later. So this is an important distinction, and one of the things I kind of referenced earlier was saying we've all had bad days, right? Having a trait is not the same as having, or a behavior, is not in and of itself a mental disability. For instance, people suffer from stress at work, right? I'm sure everyone in this room has, including us. That does not mean that we're all disabled while we're experiencing stress at work. Now, you can have clinically diagnosed stress, of course. So simply having stress does not automatically mean that you are disabled. So these are, obviously a non-exhaustive list of the types of disabilities that we tend to see most frequently in workplace settings. If you've heard of a mental disability, that's something that's not on this list. Of course, that would qualify as well, but these seem to be things that we see on a fairly regular basis, both in the context of advising employers about how to accommodate these issues, as well as in the context of litigation when something has gone wrong. Of course, we don't have to accommodate every mental disorder. So the good news is you do not have to accommodate your workplace exhibitionist. Now, you're free to do so, but that would open a whole other host of issues. So these are all potentially diagnosable mental disabilities that you do not have an obligation to accommodate in the workplace.
So basically, these are going through the elements. So the person has to be qualified for the job. So you don't have to do something to help someone become qualified. They need to be qualified for the job. So if you require teachers to have certifications, the person needs to have the certification. They need to be able to do the job with or without a reasonable accommodation. So once you realize that someone needs an accommodation, you need to start the interactive process. And basically, that's going to be you talking to them about, do they have an issue? Is there something that they might need an accommodation for? And that is really going to be a varied conversation based on what their issue is and what their accommodation is, or is considered. So first you want to assess the need for accommodation. You want to identify the potential reasonable accommodations. And then you want to select and try to implement the accommodation you've agreed upon. And then you want to follow up on it. So it's kind of a 4-step process, but the main thing is to really start and look at whether there's a need for an accommodation. So you want to first start and see, can this person do the job that they're interested in or they're doing? So you want to start there and see, is there any way we can enable them to keep doing the job they have or the job they want to be hired for? And you want to enable the person to perform the essential functions of that job. So that's where we always talk about job descriptions. Those are really helpful, and I know that's just one more thing on your plate. We do have sample job descriptions in our library, but that's helpful because then we can always say to the doctor, well, here are the job descriptions. Here's the essential functions for this person.
And if I can step in, it's not just in this context that that's important. You know, think about our discussion in hiring where we started out saying you need to define what it is the position that you're hiring for is going to do. Well, you know what a great tool for that is? A job description. We're going to talk about compensation. Job descriptions can be very useful in compensation in trying to determine whether employees are properly classified as exempt versus non-exempt. You know, so this is not just an exercise that's important in this particular context. So although it can be a burdensome effort to go and prepare job descriptions for all of the positions in your institution, these are incredibly valuable tools that are useful across all of the topics we've talked about today. And quite candidly, in every single litigation that I have with an employee that has a job description, we go through that job description at his or her deposition. Because invariably there are ways in which that job description can affect our case both positively and negatively. For instance, the case I was talking about with the woman who broke her ankle on maternity leave, when she wanted to come back to work, her doctor said she can go back to work, but she can't lift more than 15 pounds. Well, she's a nurse, and her job description very clearly and explicitly says that the expectation is she be able to lift over 50 pounds on a consistent basis, that she'd be able to walk and stand continuously. Unsurprising, a nurse in a hospital, you're going to have that expectation. That's a very useful tool for me in that particular litigation to say, we could not accommodate this person in that role because she could not do these essential functions that we've established in writing in the job description that she signed off on when she was hired.
And unfortunately, this is another place where you do have to put a little bit of thought into it because if you just mail this in, then it could hurt your case. So for example, I had a case where we didn't put in the job description that the teacher had to be able to carry things. And this was a teacher who was hired to provide Spanish. She would take all of her materials and go from class to class. She didn't have her own dedicated classroom, so she was expected to go from class to class. And bring the materials with her as she went to teach the second graders, and she'd go somewhere. And so we couldn't say that she had to be able to carry stuff because that wasn't in her job description. Now, we did say we could get her a cart, and so we put the materials on a cart, and then she said she couldn't push the cart, and so we ended up going back and forth on what an accommodation could be. But think about, you know, what am I hiring this person to do? What do they need to be able to do? And don't feel like it's just lifting. You know, if they need to be able to interact with parents, you can put that on there because, you know, if they can't interact with their parents, you know, you want to be able to say, look, this person was not doing that function because that might be something that becomes part of the case. So unfortunately, it's not just something that you can just put the 5 things down and, you know, assume it's okay. Yes?
Should a person, when they're hired, sign off on that job description?
Well,
Or be attached to their letter of agreement?
Either way,
Yeah.
I mean, I would absolutely have that signed both, you'll see in a later slide, both at the time of hire, and if you're going through an accommodations process, I would reintroduce that job description to the discussion in that context as well. Again, the accommodations process is another situation where documentation is going to be critical.
and if you are organized, having it attached to the offer letter is great. Okay, so during the meet and confer process, you want to focus on the job restrictions, not the diagnosis. So this isn't the time for you to get into all the nitty-gritty of their medical condition. You just need to find out what are they having trouble with at work. What is the issue? And then if you don't have a clear picture of it, you can request a medical certification. So that's where you can get information from their doctor to kind of shed more light on what the issues are. Okay, so when to start the interactive process? You need to do this when the employee requests an accommodation, when they present a doctor's note or something indicating that they need work restrictions, when they exhaust FMLA, or when you otherwise become aware of the need for an accommodation through a third party or an observation. And I really want you to look at that last one because that is the trickiest one. And I will tell you about a really sad but interesting case I have right now, not a school, but we had an employee posted on Facebook, I'm really depressed, my work is driving me to this, I can't take it anymore. He went to the employer's location and committed suicide. He shot himself sitting in his car. So that is a case we have, and the biggest issue is going to be, did we in any way know of his issue, that he needed any kind of accommodation? And luckily, it turns out I don't think so. So we're going to be able to dismiss that case, hopefully, on summary judgment, because he never requested an accommodation, and we never had information that would have led us to think he did need one. But we're somewhat lucky in this case because he worked in IT and he worked out of his home. So we never really saw him day to day. His supervisor didn't see him day to day. But you might have someone who you're seeing exhibiting signs of these kinds of issues, and especially with mental health issues, that's very tricky. And if you're seeing that, you would then have to say to them, hey, you know, you're not performing your job, you know, as we need it. You know, are you having issues? You might need to say something to start that discussion. You can't just say, oh, he never said anything to me, so I'm not doing anything.
And the same is true under the FMLA. There are no magic words that the employee has to say to initiate either of those processes. The onus is on us as the employer to go down that path when we have sufficient information from which we conclude that discussion is necessary. And that can be things as simple as, you know, hey, how come you were late today? Well, you know, I'm struggling with X. Okay, now you know. And now we need to start that, whether it's FMLA or ADA.
And so these are just some examples of things that, you know, may trigger that need for a discussion. You know, I need time off because I'm stressed and depressed. Okay, well, let's talk about that. You know, now, as Michael said, we all have stress days, but if this is a chronic condition, if this is real depression, we may need to start talking about an accommodation for that and including leave. If they say, I need FMLA leave, again, that's going to be something that's going to start the discussion with you. I may need time off to deal with stress and anxiety. And again, you can request medical information, so you don't have to just say, oh, they said they're depressed, you get a month off. But it doesn't absolve you of starting that discussion. You need to kind of get into the details. And I need a few days off after this back busting project is finished. So again, not everything is going to result in an accommodation or, you know, but you should at least consider it and decide, do I need to have a discussion about it?
Yes. You know, that's funny because there are a number of companies now that have PTO policies that say, you know, you can take a day off for whatever you want. You don't have to have a reason. And it's become a colloquial term to say, I'm taking a mental health day, which people use to mean, I don't really want to come to work today, and I don't have to. The first time I ever heard this was my cousin worked for Planned Parenthood probably 15 years ago. And she's like, oh, I'll just take a mental health day. I'm like, wait, what? That sounds great. So, you know, that's a really good question because I think if you've heard that colloquialism used, you're not reading that to be an indication of actual mental health issues. That's just a way of saying, you know, I'm not sick, but I didn't want to come to work today. You know, so I think maybe in that particular context, you could say, you know, I don't see this as an indication that a further discussion is needed. But I would say if that person started to get into some disciplinary situation because of attendance, you may want to have that conversation at that point and say, now look, I looked at our system and it seems like you've taken a lot of mental health days. You know, were you using that phrase to indicate that you were actually suffering from, you know, a condition that we should have you potentially accommodated for? You know, yes or no at that point, right? But I don't know that that's necessarily a situation because of the way that phrase is used that you need to follow up on that. Yes? No, you would be legally obligated to accommodate the person in that point. Although attendance in that context is an expectation, most of our schools are covered by the FMLA, for instance. So you'd have an obligation, actually, assuming you're covered by the FMLA, to give them that time off without pay. Exactly. No, and in fact, your policies should obligate them to use PTO if they take ADA or FMLA leave. You can require them to exhaust that leave to avoid having someone take a 12-week FMLA and then come back and say, and now I'm going to take my 3 weeks of PTO. Yes, sir.
If you're a smaller school, you're less than 50 employees, you're not obligated.
No, you're still obligated under the ADA. So what's important to keep in mind is that the ADA and the FMLA do some very similar things, but they also do some very different things. The FMLA is a statute where if you have 50 or more employees within a 75-mile radius, and the employee has worked for you for a year and has worked 1,250 hours in that year, they're entitled to FMLA leave, right? That's a yes or no question. If they give you, once you know that they may need leave, you have an obligation to send them a notice of their rights under the FMLA and a certification of healthcare provider. They return that certification of healthcare provider. If it certifies a serious health condition, that's the end of the discussion. And if it says they need the 12 weeks off, they get it. There's no more back and forth. They get the time off. The accommodations process is much more fluid and interactive. Employees are not necessarily entitled to the accommodation that they want. Like I said at the beginning, we're only obligated to provide a reasonable accommodation. So if an employee comes in and says, I'm dealing with this, I want to take 4 weeks off. Okay, that may be the right answer. But we would reach out to the doctor, and that's like 2 slides, and say, we need some information on how the condition affects the person and what the accommodation is that's necessary. And the doctor's note may say, needs 1 to 2 days off to handle this per week for the next 6 months. Well, then we don't have to give them block time off. We can give them intermittent leave. Or we could say, hey, maybe if we switch you to a different job for a short time period, that could accommodate you such that you could return. So we don't have to pick the accommodation the employee wants in that context. We just have to provide a reasonable accommodation that allows the employee to perform the essential elements of the job. Whereas the FMLA, they give you the paperwork, that's the end of the discussion. Yes, ma'am.
On the FMLA, I know that we can request a second opinion. We can choose another position.
Yes, only under certain situations.
Yeah, if you don't close what you did.
Exactly.
Yeah. Under ADA, is there anything similar?
I don't see any reason why you couldn't do something similar under the ADA if you had a legitimate basis for distrusting the no. Like the doctor sends you a note and says, the person can't lift over 10 pounds, and then you see him or her at Costco carrying a 70-inch flat screen, right? Okay, now I have information that I can challenge this.
And you can push back. Like we had a situation where someone said they needed to be out because they needed physical therapy. And the doctor said they needed physical therapy. But okay, but can the physical therapy be done on Saturday? Can be done after work? You don't have to just say, oh, the doctor said physical therapy. That's where you have that back and forth, to find out. Maybe it is that they have to leave Wednesdays. And then maybe you could say, well, how about you do it at the end of the day so you're only missing an hour. You're not doing it at 11 on Thursdays,
Yeah. It's like a tennis match, right? As soon as they hit the ball in your side of the court with, hey, I think I may need an accommodation of some sort, then we go back with, all right, well, get us the doctor's note. And then they come back with, all right, here's the, it's a back and forth process in that context. Yes? FTEs. Yeah, full-time equivalents, yeah.
I just wanted to share one example that I had. Because I think sometimes these are very difficult to determine if it's a performance management problem or a legitimate health issue. And sometimes it is health and they can't perform the essential function. But the employee really wants to maintain the job. They want salary, they benefits. And so even though their health maybe is making, they just can't perform the job. So in 2 cases in the last 4 years, I had to ask for a fitness for duty evaluation from a provider that we chosen as an employer to be able to say, can this person do, as outlined, the physical requirements of the position, while
Yeah,
In
the-
both cases, they kind of worked out positively for the school, but it helped to have a medical person evaluating based on the job description, whether or not this person can do this job.
Yeah, and
That's great.
transportation person going blind is sort of a perfect example of a time where a fitness for duty exam would be appropriate. That is legitimate and consistent with a business necessity, right? To make sure that that person can actually perform the functions of that job. We'll talk about fitness for duty exams, I think, in a few minutes. Any other questions? Oh, yeah.
Is it, so I've heard of cases where one employee will gift their sick time or their vacation time to another employee who's undergoing, treatment for cancer or doesn't have enough, vacation time or extended maternity leave. Is that something that is okay? Should people not do that?
So we have a lot of employers, maybe even especially over the last 2 to 3 years, who have reached out to implement policies like that. And that's certainly up to you. There's nothing wrong with having a policy that allows employees to gift or give vacation days to other folks. I'm not so sure that that's something that you really want to get into from a management perspective.
Yeah, and Aggie, I'll just add that that's actually a more complicated area than you would think, because you really need to put a plan in place and a program so you're not discriminating, everybody's offering consistently, you have criteria, you have to think of the tax consequences if you've given someone, leave from someone else, that's a benefit to them. So I have to say those are very complicated, it's a wonderful thing, but it can't just be something you willy-nilly do because it has a lot of ramifications to it.
I mean,
I think schools are doing it sort of on the fly.
Oh.
I know schools are doing it on the fly. And so that's why I wanted to hear from you,
Yeah.
because I would think it would be more complicated than that. I mean, I think communities come together around a person who's in, a difficult situation and, they want to do the right thing. It's part of our mission to do the right thing in a lot of cases, in most cases. And so I think it's really hard for sort of, to be that compliance person to say, no, we really can't do that because we want to, the head of school is like, are you kidding me? We need to do this, whatever. So I think it puts the HR professional in a situation that really, or the business officer, where they really don't want to be in the middle of, people who want to do nice things for other people and, the law, so to speak. So.
That is really, I will just emphasize, so it really is a tricky area because then if you have the head of the school suggesting it, then do people feel like they're obligated to put their leave in there? And then what if someone gave their leave and now they need more leave and they've run out? What do you know? So I feel bad because you have the head saying it's a great thing, but it really is a tricky thing that you need to really have a plan that you've vetted and you come up with criteria and you follow.
And to Susan's point, that plan is going to be a number of pages long because it has to address all of those complicating factors.
Who gets it? Do you have to have been there for a year? What if you're on performance probation? You really need to think it through and so.
So step one of the interactive process, determining the essential functions of the job. If an employee cannot perform the essential functions of the job, even with an accommodation, then they are no longer qualified and do not have to be accommodated in that context. You do, however, have the obligation to give them any accommodation that would allow them to perform the essential functions of the job. Talked about the employee's agreement regarding the essential functions. That was a reference to our job description conversation earlier. They should have already signed off on that. Nothing wrong with getting them to sign off again on the during the interactive process at every step of it. One of the best defenses we can have if something falls apart eventually is that you agreed to this. You agreed that your essential functions were X. You agreed that the accommodation would be Y. That's incredibly important in litigation down the line if your decision-making gets challenged. Essential functions are things that are fundamental to the position. It can't be done if you can't do these things. Some things that you think are essential functions may not always be. Attendance is not always an essential function. The punctuality is not always an essential function. There are plenty of jobs that can be worked remotely. There are plenty of times when you know, teachers are sick and we have substitutes. You know, you can't tell me then that perfect attendance is an essential job function if we let other teachers in other contexts miss days and have substitute teachers, right? So you really need to think through legitimately. You can't just say, I want attendance to be an essential function. It has to be a legitimate exploration of what is actually the case.
Well, and I just want to emphasize that because our schools are so nice that we often have, like, you know, a parent who's struggling comes in late, you know, for a bunch of days because they can't get their kid to daycare, and then we have somebody else who, they're late all the time, we're going to terminate them or not going to accommodate it. You know, if we've let it happen, you have to understand that that has implications on other issues like this, that you then later can't say, you know, attendance is key.
Oh yeah, you know, we would be having a very bad conversation during a litigation if you fired someone for coming in late and then I found out that you'd been letting other people come in late who were not disabled. We'd be talking to your insurance carrier about some additional money. Again, you're going to want to talk to the employee about what it is he or she can and can't do. That's where this should start in terms of figuring out what it is we can do to accommodate that employee. Susan referenced, we can get medical documentation. The last bullet point, an ADA questionnaire, you know, we have form questionnaires that can go to a doctor that say, you know, does the employee have a mental or physical condition that substantially limits a major life activity? Check yes or no. How long has that condition been in effect? How long do you expect it to last? How is it limiting? Attached is a job description. What aspects of this job description can or can't the employee do? What accommodation does the employee need in order to be able to do the things, if any, that she can or can't do? And then we take that doctor's information, and that's where the rubber really meets the road. We're going to look at that and say, all right, the doctor says that this person needs to take a 10-minute break every 2 hours. Can we do that? And you're going to say no. And I'm going to say, okay, really can we do it, or really can we not do it? That seems like a pretty easy thing to give. Tell me why we can't do that, right? So we're going to take that doctor's note and evaluate what the restrictions are and what the recommendations from the doctors are to figure out whether that's something we can or cannot do. You know, the good news is that 8 out of every 10 of these are things that are generally relatively easy. It's a no lifting over 50 pounds. You know, to Susan's example, all right, we'll give you a cart. Can you push this cart with your books? Yes. Perfect. That's an accommodation we just provided. Great. It's those really dicey ones. I need 6 months off because I'm battling cancer. I need, you know, 9 months off because of X. You know, whatever. I got in a really bad car accident and you know, have to have a hip replacement. You know, that's where we're going to have some difficulty in going through the interactive process. But just know that we're entitled to the medical information. We don't necessarily need to know the diagnosis. 99 times out of 100, it's going to be shared. But you don't need to have the doctor say what the actual condition is. It's generally going to be sufficient to say, yes, they have a mental condition that affects their ability to do X without having to know that it's PTSD or depression or whatever the case may be. We can send employees for independent medical examinations. You know, we can't basically send them in and say to the doctor, hey, yeah, figure out everything that's wrong with this person. You know, they have to be limited to what we're dealing with at the time, those limitations and conditions that are at issue in that particular accommodations process. And we pay for it. The next step after we've gotten the doctor's information, as I've suggested, is that we think about what are the things that we can do to accommodate. You know, we've gone through a number of possible accommodations. One I really want to highlight is, as we go through the process of saying, can he or she do this job? If the answer is looking like no, and we're feeling pretty confident about that answer, you know, I'll go back to the transportation driver that we talked about earlier who's losing his eyesight. That's a pretty easy answer for an accommodations problem actually. That would be one of the easier ones I got. No, he cannot drive anymore. The next question should be, are there other positions available at the institution that this person is qualified to hold? that may not have been the case for the transportation driver. He's not likely to be qualified to teach, ninth grade geometry. Maybe he is though, and if he is, we should look at that and say, do we have an available position for that person that we can transition him or her to? You don't have to create new positions for disabled employees in order to accommodate that. You only have to look at available positions. I would also say, anytime you feel like you're being cute in this process, you should stop and reconsider. And what I mean by that is, we may have a contract period that ends May 31st, and we don't have any available positions on May 28th when the person asks us for a transfer. But we know we're going to have 6 available positions on June 1st. You can't go back on May 29th and say, sorry, we don't have any open positions, we can't accommodate this. Good luck. You would in that context be obligated to give them 3 days of leave and then evaluate whether they could transfer into any of those other oncoming positions. That's what I mean. You can't use timing in that type of context that would really be specific to what we're dealing with respect to schools to try and avoid going through that process. The court's going to look at you and say, are you kidding me? You didn't have any, I understand you didn't have any on the 29th, but you knew you had 6 coming up on June 1st.
Even if you consider, I'm thinking of long-term sub, it's going to be a little bit around, to go down and manage that position.
No.
Maybe they don't want to bring that, maybe the person could teach geometry, but I want to teach them, but I don't want to teach them geometry. Who knows that position is open, they have to, you still have to interview. I mean, like, just because they could do it.
Well, it depends on what you mean by just because they could do it, right? Like, do they possess a degree in geometry is a different question than are they actually qualified to teach geometry? So if he has the prerequisite credentials, but has never taught a geometry class in his life, he's not qualified to be a geometry teacher.
Like, you don't have to lower your standards. Like, if you want experienced teachers for your teachers, you don't have to say, well, this guy's never taught, but he does, you can still say, no, he doesn't meet our standards.
But if he meets your standards, if he's taught 30 years of geometry, we would be having a very hard discussion about the potential outcome if you don't give him that job that he's qualified for, meets all your criterion for, and you're going to hire someone else for
That
it.
person hadn't taught science for 10 years.
Exactly.
But he's in there, but, because that person obviously a job, I'm like 2 years from retiring. So yeah, I want to teach that job, just escape with it.
Yes, that's a qualifications question at that point. And to your question, if you've also decided you're not going to fill that role, no, we're going to eliminate that position, right? That's fine. You're allowed to make that decision. Don't hire someone 6 weeks later. Because we're going to be, the thing about litigation to keep in mind is the cases that I'm dealing with now, the people were terminated in 2016 and 2017. So if you decide, we're just going to tell them we're getting rid of the job, and 2 months later you filled it and hired someone else, we're all going to know about that by the time we're in court. And again, we're going to be having some very tough discussions about our defenses in that case.
Is that all at the same pay rate when you're switching someone from one job?
Yes, you would pay them at the same rate as the new job.
Can I ask a question? Is there a safe amount of time to wait before you replace that position that you eliminated?
No. Business needs can change. So when we're talking about stuff like that, I always want to see a justification for the change in position. So let's say you decided for 2019 we're not going to have 3 geometry teachers, we're only going to have 2. And then halfway through 2019, for one reason or another, you get 10 new students. A school closed down and you were nice enough to take in some of their students, right? That would be a change in circumstance that would easily justify you hiring another teacher in that context, right?
Mm-hmm.
That's not going to look like you were just trying to get rid of somebody in a tricky way. So you're going to have an actual business justification for both decisions. Whether it's enrollment related and that changes, that's fine. As long as what you said at the time was legitimate. Is that fair?
Yep.
Yes.
There's a scenario where we have a teacher who is
Sure. So in that particular context, the good news is there's no ADA question, right? The ADA only covers employees' own disabilities. So if the employee's missing time to care for a sick parent, that's not an ADA problem. We're not going to go through an accommodations analysis. It's an FMLA problem.
But if it's affecting them and their stress, and they're like completely like, and even like they're not functioning.
Well, that goes back to the question of, are we dealing with something that is just stress that everyone's dealing with, or are we dealing with a diagnosed medical condition? And that's where it becomes, I don't know if your FMLA, if the FMLA covers your school or not. If it does, that's a situation where you would have to send your FMLA letters. Even if she told you she didn't want to take it, you still have to send the notice letter and let her not return it. Great. The FMLA problem's gone if she refuses to return the certification paperwork because she doesn't want to take time off. That's fine. It would then potentially be incumbent upon you to say, look, if you're suffering from a medical condition that is affecting your ability to come to work, you know, we can talk about that. You need to get us the documentation on that. And if the response is, well, it's not, you know, I haven't been diagnosed with it, I'm just having a rough couple of months, well, that's, again, not an ADA problem. If you get the doctor's paperwork and it's, yes, this is a diagnosed condition, then we go through the interactive process. If the employee refuses, I don't know if that's on this slide, maybe on the next one.
Does that make sense, though? It's not like any depression, like we all go through periods of depression and stress. She'd have to show that she has like the clinical diagnosis of depression.
Right.
And then it would be something we'd consider.
There would be some for less than 50 employees who would work the other FMLA.
Great.
But as far as like even considering terminating the employee.
Yeah, let me get there. So you would go through that reasonable accommodation process we just walked through. If the employee says, no, I'm not taking time off, I don't want this. If an employee breaks down the interactive process, if they're responsible for the breakdown, that's on them. We can then move forward with whatever discipline is appropriate based on our policies and the time that that employee missed. So once you've gone through those two, you know, in your case, just the ADA piece, but in other cases, the FMLA and the ADA piece, and the employee has refused FMLA or hasn't returned paperwork or won't accept the accommodation that we've suggested, whatever the case may be, once that's all gone through, go ahead and discipline and terminate under your policies at that point.
Now, the trickier thing, just to change it up a bit, would be if she did have clinical depression and she was randomly missing classes. And that is a tough situation. And, you know, there is case law that indicates you don't have to just let someone sporadically take, you know, you don't have to accommodate like sporadic, unknown leave. But I have to say, I would be careful of terminating in that situation if she had clinical depression, because you probably are tolerating it from other teachers in other circumstances. So,
Right, and that's where you go through the interactive process, right? When you get that documentation back, if it says, you know, thumbs up, yes, disability, then you go through the process. If it's not returned, your obligation is over. If it's returned and there's no disability, your obligation to accommodate is over.
Now, I will tell you that I've had schools where we've had this discussion, and they've said, look, I can't have the second grade teacher being out 15 times over the next semester, and that's a gray area, but we're going to terminate, and we're going to take the risk that she's going to sue us, because we can't lose enrollment because 5 kids withdraw because second grade is falling apart. So, you know, sometimes we can tell you what the legal risks are, but you might say, look, this is worth it, because and we're going to take the risk of a lawsuit, and we're going to deal with that. And maybe they won't sue, because sometimes, you know, they find another job or they do something else. So it's a discussion you can have.
And that's exactly why this aspect of the law is the most frustrating for our clients to deal with, both at their workplaces and with us. Because they'll call us and say, well, I can't have this. And we'll say, well, this is going to be a tough case. Because on some level, a teacher missing 15 days in a semester is not necessarily inherently unreasonable. And that person may be able to point to someone who missed 11 days last year. And is the 4-day difference really a sufficient enough distinction? Or, you know, if you're FMLA qualifying and they're either out of time or they haven't been there the requisite time period, you know, I'm going to say, well, other employees have missed that amount of time. It has to be reasonable here. But, you know, when you get into those gray areas, to Susan's point, you know, we can only go so far before it's I don't know how a jury and a judge is going to react to this. Here's the good news. That's a compelling case. We have second graders. They need consistency. We have parents who expect consistency. And the teacher in that context is not doing a good job of teaching the students. On the other hand, missing 15 days in a semester is not a whole lot of time. There may be other times where you know what I mean? So at that point.
The judges are very tolerant too. They really make our employers do a lot to accommodate, which, you know, can be good, but so it's hard. We get it all the time where schools are like, oh, this is a hardship. Okay, we can try, we can argue that, but honestly, they really make you do so much that it's hard to say that's gonna win the day. So when we have the discussion, you know, it's perfectly okay to say, look, we're willing to take the risk because our business interests mean that we need to go a different way, so.
Yeah, I mean, the frustrating thing about the accommodations process generally is that, you know, how many times have you been to an HR seminar and they've told you, you know, consistency, consistency, consistency. Treat everyone the same and you don't have to worry about discrimination. This is quite literally the exact opposite message. You cannot treat people consistently when you're dealing with an accommodations process. You need to tailor your accommodation to their specific needs. And candidly, the needs of one employee who suffers from depression may be dramatically different than another employee that suffers from that exact same condition. And you're going to need to tailor your accommodation to each of those employees based on how their own condition affects their ability to work. Does that make sense? Oh, I'm sorry.
Hi.
Yes.
Would you address the third-party observation piece? Because I've had situations where there was a teacher who had some performance issues, some collegiality issues, didn't disclose, but then a staff person, as we all know in school, overheard this teacher talking about mental health issues, and then came to the administration. And if you would go over our responsibility to then talk to that person about their performance. And the other part B to this, because I'm going to forget it, is when you start to accommodate for somebody, and it's all supposed to be confidential, any guidance on how you deal with this with the rest of the staff. You know, like, oh, you know, they're allowed to come in late, or they're allowed not to have these extra responsibilities.
Sure. So the first question is, an employee who overhears the employee at issue referencing what could potentially be a mental disability.
And that person doesn't want to disclose. The person that has the mental health issue doesn't want to disclose.
So remember, our obligation only arises if an accommodation is necessary. So we really have to think about what the message is that we're receiving from the overhearer. Let's call him or her. You know, if the overhearer comes to us and says, I just heard Bob say that the reason he's been coming in late is that he suffers from depression. Yes, we now have we know that information. We know that the potential disciplinary issue is maybe related to a disability. Once we have that information, we need to go and approach that. You know, hey, Bob, you've been missing a lot of time. Somebody told us that, you know, this may be related to a health condition. If so, you know, we can work with you on an accommodation. We need you to fill this paperwork out. If it's just, you know, I heard Bob saying that he has depression. Well, there's no obligation for us to do anything in that context because there's been no evidence that at that point an accommodation is necessary. If, however, going forward, you see Bob exhibiting behavior that may demonstrate his need for an accommodation associated with that mental condition, once you have that knowledge, you want to go through that process. So again, then the ball goes into your court to take that first step in the interactive process and let Bob decide, you know, to go fill out the paperwork and work with you to figure out how to manage that. But if it's just sort of like the gossipy, guess what I heard, you know, there's really no action for you to take at that point, other than to just put it in the back of your mind. If there's ever an issue where you think Bob needs an accommodation, to say, you know, to take that first step in the process.
And Gail, if they don't want to get into it, they say, oh, I don't have an issue, I don't want to get into it, I don't want to talk about it. Okay, well then you've done your part.
Yeah, and document that.
Yeah.
Talk to Bob today about what I overheard. He said everything was fine and he didn't need anything.
But if it's affecting their performance, and then when you get into the performance evaluation and
they disclose after the fact and say, you know, oh, by the way, I really couldn't, you know, keep up because, you know, I have depression and anxiety, but they didn't come to us first. So if they've gotten to the point where we have to let them go, it's okay?
Yeah, we're gonna press pause on anything like that, in that context, and we're gonna wanna walk through that on a step-by-step basis. Because once we've been notified that that is related to a mental health condition potentially, we're gonna wanna press pause on the disciplinary process, because our obligation to accommodate still exists. Now, that's not to say that we can't hold him or her accountable for some of those absences, but I would be very reticent to terminate an employee who we know had a mental health condition that caused the performance issues for which we are about to fire them. I mean, that seems like just a recipe for a disaster. Yes?
But I think what she's saying is that she didn't know about the mental health issues until after the performance appraisal.
But
and then-
before the termination.
Right.
That's the problem.
Okay.
If you terminate.
Terminate and quit, yeah.
And a week later, they're like, yeah, but I had depression. It's like, well, what do you want me to do about that now, right? But if you know about it before the termination decision happens, your obligation to accommodate is going to kick
I mean,
in.
you're at that edge of terminating.
Yeah.
You know, they've done a lot of things that they shouldn't have done, you know.
And that's why I'm saying, you can probably still hold them accountable at some level, but I would be very, very hesitant to say, sure, go ahead and fire them. Because, not to mention the fact that the termination's coming days after you were given knowledge of a mental health condition. So that's not even an accommodations thing, that's a disability discrimination thing. And that's a disability discrimination thing that's likely gonna go see the jury. Because they're gonna say, well, I wasn't fired until literally 2 days after I told them I suffered from depression. But not only that, we now know that there's an issue related to these absences. The mental health issue, in fact, may in and of itself be preventing them from coming to tell you about the absences. And so we're going to really want to look at doctors' information and see how can we both accommodate this employee, avoid liability, and still make sure that we don't have to say, just totally forget about all of these absences. And that's why our clients hate talking to us about accommodations.
We have mental health though.
If you already have somebody in the midst of a performance improvement plan though, because they're exhibiting and it doesn't come out in all that time, that my performance is poor because I suffer from depression, and then you get ready to terminate, you're still?
Yeah, oh, absolutely. I would still want to hit pause and figure out what the appropriate reaction is. Because again, you're obligated to provide a reasonable accommodation. So let's say that we have an attendance policy that 9 absences and you're gone. And he comes to you on the 8th absence, right after you gave him a final warning and said, you know, I'm suffering from depression, and that's really been the reason why I haven't been able to be here. Now, do we have to go back and excuse all of those prior ones? Maybe not. But the final warning, that may be something I would say, yeah, we should probably take that one away, right? And then we're going to want to look at what the doctor has said about all of the other absences and decide whether it is a reasonable accommodation to take all of those away, or decide, you know what, there's not substantiation for those first 5 absences being covered, so we're just going to count those, but maybe we'll get rid of the other 3 because he's presented us with the doctor's information covering those. But again, it becomes such a fact-specific inquiry in all of these situations, because we need to know the particulars of the violations, we need to know the particulars of the condition, and we need to know how those two interact to see what is reasonable in this particular context. And that's, you know, that kind of goes back to like, everybody's been telling you for years to treat everyone consistently, and now we have to do a very independent and focused analysis for each of these situations, and the answers are going to be different every single time, most likely.
And then in contrast to a physical disability, when it's mental and it's sort of invisible, how then do you know, communicate with the rest of the staff that this person is getting, you know, special treatment?
Yeah, you never want to communicate that somebody is suffering from a disability in the accommodations process explicitly. But there is nothing wrong with saying, you know, we are aware of the issues, and you know, management is handling them as we see fit or as we're required to do, or whatever, you know, whatever the message is. You know, we're aware of it. We know what's going on. Mind your own business. But maybe in a nicer way. Any other questions? I made it to you. Only took 45 minutes.
Okay, so a lot of different accommodations could be required. Some things you don't have to do. You don't have to reallocate essential functions of someone's job, but you might want to reallocate non-essential functions. So if that person could still do their job, if you reallocated non-essential functions, that would be something you would want to do. Changing the start time could or could not be something, you know, with a teacher, probably not. Although, you know, one thing to be careful of, and I think Michael's going to talk about a case, is as you start letting your faculty do different things, that is going to be something that you're going to be viewed as able to accommodate. So like in the case he's going to talk about, they let teachers do non-teaching jobs. So then you can't say that your teachers have to be able to teach in a classroom because there are now non-teaching jobs. So like if you let your administrators start working from home, you can't then say they have to come to the school and be on campus because you've now accepted working from home. So just keep that in mind. I know we're trying to be flexible with our workforces, but just keep that in mind as you're, you know, it might be okay for Sally because you love Sally, you want to keep her, but just keep in mind that you've now let that be something everybody else may be able to do. And reduced or part-time schedules can be accommodations. Okay, so one of your teachers has been treated for depression, panic disorder, and post-traumatic stress disorder. His doctor releases him to non-classroom work only. School assigns him to substitute teaching and then regular classroom work. He sues to stop the school from requiring him to work in a classroom or perform duties inconsistent with his doctor's orders. And this is actually a recent or a local case with one of our schools. So this is an actual case that took place. So what is the result? What do you guys think? So he's been treated for depression, panic disorder. His doctor says he can work, but non-classroom work only. What kinds of things would you think about? You might want to do that. Yep. Any other considerations? Okay, well, I actually lied. This is the one I just mentioned, where in this case, the school had non-classroom teaching positions for teachers. So this would then go to the jury to decide, should the school have allowed him to take a position like that where he wouldn't have to actually teach? They had teachers doing research and other types of things. So the court said, well, you can't just say he can't teach, so he's out of a job. And in that case, interestingly, although he was treated for those issues, depression, panic disorder, the court also said they would have to decide whether it was a chronic or temporary condition. So again, if your depression, you know, you're just depressed last week or it's a recent thing, but in this case, I think, you know, he was going to make it because he really did have long-term depression that he could document. But that was an issue that was going to go forward. So other possible accommodations you should consider, and courts have allowed, working from home. So that can be something. Now again, it depends on the type of job. You know, like a bookkeeper could probably do their work from home. Teacher, no. But you do want to just not write that off as a potential accommodation.
And we've had cases where workforces have said, oh, we don't let people work from home. It's like, yeah, that's not the question. The question isn't whether you let them work from home. The question is whether attendance at the office is an essential job function. And if it's not, then allowing them to work from home is an entirely appropriate accommodation.
And so Michael already touched on this, but one thing to consider too is whether you can transfer them to a vacant position. And so that is an accommodation courts would expect you to consider. Now you don't have to start a new position, you don't have to create one, but if there's a vacant position that they may qualify for, you do need to consider that. Interestingly, you do not need to violate seniority unless exceptions are commonly made. So, you know, if there are certain requirements like that, you can still make people comply with them. But again, don't, you know, hang your hat on seniority if you've let 3 people skip that. And you can pay the lower rate for the position, even if it's lower than the rate for their current position. But again, try to exhaust that they can't do their current position first, because that could raise a claim if you drop them to a position where they're going to be paid less. Does that make sense? Yes.
What about the other benefits? For the, in a transfer of position? Because some, I know some positions may have access to, different level of
Mm.
whatever, so do we have to?
No, you would be transferring them to the new position as it exists.
So you could offer the lower benefits. Yeah.
Keep in mind, from a litigation perspective, every time you make the position worse, you make the chances that they're going to file a lawsuit better, right? So if there is any flexibility, it's not going to hurt. Or in that context, considering a temporary transfer may be the right result. So you may want to say, look, we're going to put you in this job for 6 months. When you're ready to go back to your old job, we'll put you back in your old job. But no, if it's an open position that is the only other option, then they go into that position as it exists.
Okay. So another type of yes.
You have an employee who's been given an accommodation and the functions of the department are not working out very well, and you decide to outsource the entire function. Is there any liability?
Well, you're always allowed to make those business decisions, right? As long as it wasn't because of the person's disability. The question of liability, though, is what is a case going to look like in that context? Are you going to see a lawsuit if that happens? And there are varying, the likelihood escalates depending upon the facts, right? So if you've outsourced an entire department and one of the people in it just happens to be someone you're accommodating, that on its face is going to be a very strong case if it's brought, and not one that's likely to be brought. We have a classic, this often happens with reductions in force, right? If you have a reduction in force that's 500 people wide, I doubt anyone in this room is going to have that, right? But, and one of the people that gets caught up in it is someone who's on leave or, is being accommodated. That's not a very dangerous decision to make. The problem comes when we see reductions in force of 1. And you just happen to eliminate the one position that has the person who suffers from depression. Now, that may be a legitimate business decision, and we may be able to demonstrate that it was a legitimate business decision unrelated to that person, but the strength of that evidence is going to determine the strength of that case.
But it would be a bad case as you've described it.
Let's say they teach Spanish, and you have no kids next year sign up for Spanish. That's an easy case to say, well, yeah, we eliminated the Spanish teacher because we don't have anyone taking Spanish, right? That's easy. Others are, you eliminated an administrative assistant position, but you still have like 17 others. And it's like, well, that's interesting that you picked this one.
Okay, so a leave of absence is definitely something you need to consider. We get this question a lot. You don't need to accommodate an indefinite leave, but, be reasonable. Sometimes people say, I'm going to come back. It looks like I'm going to be able to return in 6 weeks. It may be 7. You can't say, well, it's indefinite. You have to be reasonable. There may need to be follow-up with the doctor and make sure, they're going to return, but some flexibility is going to be required of you. Same thing with tolerating erratic attendance. I mean, technically, it's not required that you accommodate that, but really be careful, because if you're letting it happen in other contexts, the court's going to say you could tolerate it. Okay, so examples of reasonable accommodations: modified work or break schedules, letting people have quiet areas to decompress in, time off for appointments or leave, working from home arrangements, changes in supervisory methods. Although there was a case where you didn't have to change supervisors, so that was not required. And then reassignments. So accommodations that are not reasonable: lowering the quality or standard of the position, eliminating an essential job function, creating a new position, transferring, moving the employee's desk away from others, and indefinite leave. So misconduct. So the employer does not need to deal with misconduct. You don't have to tolerate misconduct. But you do need to consider whether a reasonable accommodation would eliminate the misconduct. So be careful that, you know, you don't just say, well, this person's doing this and we're going to fire them. If there's some mental health issue that may be causing that, you still want to have the discussion to see if, and it may be in that situation, a reasonable accommodation is not going to stop the misconduct, but protect yourself by at least starting the process.
And that's why when we were discussing earlier, getting to that final stage, you know, I'm saying, we don't want to terminate because now we've got this information in this context, but we may be able to go back and still hold accountable for some of those prior absences, you know, subject to our reviewing the circumstances of those absence and the circumstances of the doctor's note.
And so there are situations where courts will find it's an undue hardship, but I have to tell you, in our setting, it's rare. So I would really try to talk it through before you just terminate based on hardship. A lot of these are not going to apply to you, like decreased productivity, decrease in customer responsiveness. But, you know, there are situations, if you had a really small school and you couldn't deal with something, we could certainly talk about whether it's a hardship. But we just find courts are so over the top in allowing the accommodations that we're reluctant to rely on that.
So if the interactive process doesn't work the first time we go through it, we can't just say, all right, well, we've gone through the interactive process, we're done, have a nice life. We do need to determine whether other reasonable accommodations are available. This is, again, a very frustrating aspect because we've just gone through that 4-step process we outlined, and now I'm like, oh yeah, no, go back to step 1. You know, it's a little more, it's a little easier the second time around. But if we've gone through that whole process and said, okay, maybe the cart is okay and you can push the cart and that doesn't work, we need to go back and say, all right, is there some other accommodation that can account for this? Again, obviously, throughout this entire process, every aspect, especially of our back and forth between us and the employee, needs to be documented. As I said earlier, if the employee is at fault for the breakdown in the process, there's no liability on the employer, but I want to see excellent documentation on that. There have been times, for instance, when I've had a case where the employee went through the whole process, agreed to the accommodation, then came back to work and on the first day said, I'm not doing this. And they said, that's it, we're done. And the court said, look, the employee was responsible for this. The employer did everything that they should have done. They agreed to an accommodation, and then the employer refused to abide by it and didn't identify any other accommodations that would work other than one that was unreasonable as a matter of law, which was she wanted her supervisor to be replaced. We don't have to do that. Good news. All of that was well documented in that case. When are you done? Never. If the accommodation is no longer needed, you can stop it. If it's successful, you know, if the person has recovered from a condition, you can stop the accommodation. You can stop the process if there's no reasonable accommodation that exists. Again, as I said, if the employee fails to cooperate, or if it's an undue hardship or a direct threat. Don't forget about the FMLA. We've talked about that. We can do fitness for duty examinations in certain contexts. Let's talk about the direct threat. An employee is not entitled to an accommodation. I should say an employee is not qualified if they present a direct threat. You know, we've all seen stories of workplace incidents where likely evaluation of that behavior beforehand could have prevented it. That's where the direct threat analysis comes into play. The direct threat analysis is a very fact-intensive one. You need to be able to show that the employee presents a significant risk of substantial harm to himself, herself, or to their coworkers. You know, some of those contexts are sort of easy to evaluate. You know, I'll go back to the gentleman who's losing his sight. You know, that could very well become a direct threat analysis because someone who can't see well driving a car poses a direct threat to himself as well as the people around him. We've had cases where the direct threat analysis was at issue in a warehouse setting where somebody lost their hearing. And you couldn't hear the beeping of the machines driving around. that posed a direct threat to that employee and others. Okay, right now? Okay. Perfect. Yeah. All right. That is the direct threat analysis in a nutshell. So if you have an employee whose mental condition you think poses a direct threat, you can go through that, send them for a fitness for duty examination, take them out, put them on paid leave, and remember that a jury and a judge are going to be evaluating the facts eventually, potentially, and so if you're able to articulate why you think that's a direct threat in a way that all of us would be compelled to understand and appreciate your position, that's likely to be a justifiable decision, especially when we take it in the context of some of these other, national headline stories we've seen. So if you have cases where you're worried about that, remove the employee, put them on leave, send them for a fitness for duty, and just be able to document and explain why you felt that employee posed a substantial harm. And you can't rely on, it has to be objective. You can't be like, well, we all know people with depression are more likely to shoot other people. That's not the right answer. It has to be, something that happened that the person said or did that suggested they were posing a threat. It's 2 o'clock exactly.
We're going to give you a quick break. You guys want to take a quick break?
I mean, we can keep talking about direct threats all day.
I think the ladies' room on this floor is out of commission.
It's back in the game.
Oh, it's back in the game? Okay.
There's also another one above on the second floor.
Or like two. That might be something you want to get.
Okay, I can do that. I think the wage stuff should be pretty quick. I can do my stuff on that.
Okay.
And I don't think they're open. You're laughing at me because, I'll talk for like 50 minutes. Hello. Yes, of course. Yes.
So you have
Where should I submit my application?
I was just saying, we gotta do this. Well, Sally first.
Yes.
Come help us.
Wow.
We don't want to, we have no. So
Gotcha.
should I get you through? Need to blow that out.
Gotcha.
But, so when people, when their FMLA expires, they, maybe they use some of that for their, but they still have a lot of good time.
Sure.
So we have a, how much you know about request for university with or without pay. It's a situation.
Okay.
So what we're running into is, when they're not, we're comfortable, we can move along.
Does your policy allow them to take paid time off in like a chunk that's big, that's that big? Because normally policy, so that's a little different. So your policy under the FMLA can say, if you take FMLA, you are required to use your PTO. Your PTO policy separately can say, you get X, you're entitled to carry over 120. However, you can use no more than 15 consecutive business days of leave. So you could have a restriction. Exactly. So you could have a restriction on their, exactly. Maybe 15 is not the right answer. Maybe it's 30. You want to let people take a month off. But you could have a restriction from them using all 120 consecutive.
So would that go, so we have parental and family care leave, so some maternity leave, so we have to make sure. Would that go in strict policy, would that go in leave policy? Right now, our leave policy is basically at the discretion of the area vice president, if we're gonna grant it or not.
Okay. It should go everywhere. Every policy should identify, so your FMLA policy should identify the requirement to exhaust or use the PTO. The PTO policy should identify what it is, what the restrictions are, and then have an exception for family leave or disability leave. Because you also want to, someone who takes FMLA and then they need to stay out longer because disability and they need another month, you'd be required to give them that accommodation. So you also want your accommodations policy to reference exhaustion of PTO. So every policy should sort of say, what do we want the results? We want, when people are out on protected leave, to be using all of their PTO, so they can't come back and do it. And we also want our PTO policy to say, you can only use this many consecutively unless it's being used under our ADA leave or our family leave. In which case you'll be required to use it during that period until it's used. But there's nothing wrong with that.
So, giving them like it's easier.
Yeah.
Under if there's a leave of absence for them, it's like a full semester or a full year.
For a couple of reasons, it's hard to, then you have to replace it semester. Also, it goes through their.
Yeah, you can have separate PTO policies for academics and for staff. The staff will love that.
We should have, well, right now,
It's
actually,
true, but it's too big.
right now, faculty get a week for them off is only 3 days of substitute.
Sweet.
So you should apply to
As a JD, what courses am I
business
able
school
to
take you. Yeah, absolutely. So we should have an FMLA policy.
Yes.
We should have
an ADA policy?
ADA policy.
Yep, an accommodations policy.
Accommodations policy. We have guidelines for requesting accommodations.
That's fine. The accommodations policy would just be something that says, in the event that you suffer from a disability as defined by the ADA, yes, and you feel like you need an accommodation, reach out to you.
Yep, that's what it is. So that is what that says. We have a vacation policy, a sick policy, separate.
Okay.
What else do we need? And then we have a what happens after you exhaust FMLA, or if you're not eligible for FMLA, or if it doesn't qualify.
It sounds like you have everything you need. You just want to make sure that all of the things say what you want them to say.
And the parental family care.
So we need something to cut them off, not want them to use 3 days in one shot.
Yeah. And that sounds, yeah, you could say that actually. That sounds like a relatively easy fix. If you have a policy that says you can bank 120, you can just add to that. However, you're not allowed to use more than X consecutively unless under policy A.
Yeah. So, on an approved leave, and not be able to pay for all of it, we're not gonna let you take more than 45 days consecutive.
No, if you're on a...
Could we, but if somebody needs,
No.
so if somebody needs 45 days, where we say you can't use more than 50, we want to accommodate.
No, our policy would say, unless you're using leave under the family policy, the parental leave policy, or our ADA accommodations policy, you can only take 50 days. If you're using leave under those other policies, you're required to use it until it's exhausted, or until you
So
return.
50 for the first scenario that you said, that you can only take 15 days. I guess what we were thinking is we're saying you can only use 15 days of sick. You're saying.
No. So let's think of 2 buckets. Let's think of just our PTO. There's no health condition. It sounds like you want to put in a policy that says you can bank 120 days, but you can only use X consecutive, so that we don't have people just going away for half a year, right? Heard of it. So in that context, we could say, if you're just using PTO, here's the rule. However, in the bucket of leave for ADA reasons or FMLA reasons, you have to use all of your PTO while you're on leave.
It's when there's a medical condition that is continuing beyond FMLA.
Then that's going to be an ADA leave, and so you would still want to have them using all of their.
So in the discussion,
No, you can actually, as a matter of law, you cannot put
at the end of
an end to
So if
mediation.
the teacher comes in, let's
The
say,
court would look
at
at that and say
the
that's a
beginning of
per
the
se.
year and says, hey, I'm
So
gonna be.
a lot of companies used to have a 6-month maximum.
Whatever doctor
They would
related
say,
thing.
you can have FMLA,
Do we have
if you're not ready to return to work, we'll give you 3 more months, but if you can't return after 6, you're fine. And the courts have said, you can't have a policy that per se limits the ability, because it may be a reasonable accommodation to give them 7, based on the needs of your particular institution.
So in case we have one particular person, and that person goes to our, you know what, I'm gonna have government guy or something like that. If you don't, not have an ADA, it's not. Okay, you're gonna be liable. A lot of times the
Then you can
contracts
cap it.
are done in February
Right?
anyway.
But if it's an
So
ADA
that's part
situation,
of
you
the
can't have a
problem.
maximum.
They could say.
As a matter of policy.
If we're outside of the FMLA. Okay, we're an ADA company. How do we get a second analysis?
Yes, you can do an independent medical evaluation.
That's the issue, I think. It's just a question, yeah, that's my question.
Yeah. Trying to find the slide. You know, you can do
Some of these
fitness
things
for duty
require
only in special circumstances. But if you have some reason to feel like you have incomplete information, so if it's like, you know, the doctor's saying one thing and he's saying another, or the reality of the situation isn't driving with what you're being told, then you can send them for an independent medical evaluation. But if the doctor says to you, this
I know,
person
and that's, but what's the purpose
has
of a medical
needs a hip replacement, has chronic pain, that needs to be out for 7 months, and you have no information to suggest that that's untrue, I'd be hesitant to send for an evaluation.
Some like they're just a hassle.
That
But the
just
job
seems like you're going after them.
description.
Yeah, I'd want you to be able to articulate it. You know, whether it's
Most of my teachers were, but he was saying that if you're doing this, this, and this, they need to actually employees. So now I'm reading.
well, that's good. Generic is good.
What is that? Yeah.
How long has he been out?
Yeah, it's just, because we have a vocation. So we have
Well, no, she won't. She has to have worked 1,250 hours in the preceding year.
So because
So
she
she
has.
won't be eligible for FMLA.
The carpentry guy doesn't have his own business, the welding guy doesn't choose. So they might be different. Okay. Well, see, that's why she'd have to use it, because the little things.
That doesn't count towards your.
I was in regular elementary school, and she was.
So she's been out for a year.
Now.
She's never going to get FMLA again until she's been in the office for 1,250 hours. So that's as you get closer to a year, you get closer to a point where everyone's going to say, this is right. Now, the downside for you is that you're a bigger organization. So what you can put up with, it's much more than the people that have gone to were like 25. I may say to them, yeah, 5 months. I can talk more.
I think Aggie wants us to get started. I thought we do her getting to re-up.
Sure.
What she was thinking is to say to them, hey, look, we're going to finish up alcohol on FMLA, or rather on ADA, but then I'd like to hear about compensation issues, just random compensation topics that have come up, or social media issues, or child abuse recognition, or
Okay, cool. All right, I think we're going to get started again. The good news is you've all been engaged in asking us a lot of really good questions, and I appreciate that. The bad news is that means there's still 8,000 pieces of information to give you in 47 minutes. I'm going to run through the drug and alcohol, how the ADA and FMLA interact with drug and alcohol abuse. This is a particularly relevant topic these days, unfortunately, and there are some very specific things you can and cannot do under those laws. After that, we have 3 other topics, and we're gonna allow the crowd to choose your own adventure. All right, so alcohol and drug issues. all are covered by the ADA and FMLA in different ways. The ADA says rehabilitated drug addicts and alcoholics are disabled within the meaning of the ADA, which would subject them to entitlement to accommodation, whether it be for continuing treatment, attendance at AA meetings, etc. Recovered drug and alcohol abusers are qualified individuals under the ADA. However, a current user of illegal drugs is not. If you have an employee who is caught using illegal drugs, they're not qualified under the ADA. Current users of alcohol are, which is great news for most attorneys, for the very practical reason that most people drink alcohol and are not alcoholics, so we can't have a per se rule that if you drink alcohol, you're not disabled. Current, as the EEOC defines it, and as the courts have defined it, means that the employer has a reasonable belief that drug use is an ongoing issue. And we actually just won a case a couple weeks ago where this was one of the main issues. The woman who was a nurse had been caught at work using opiates. She then presented a note with a prescription, and they allowed her to return to work. She continued to use, unfortunately, and eventually went into a rehabilitation facility. And the court said, during that entire time, she was not disabled under the ADA because she was currently using drugs. Great news for our case. The question then became, when following the release from rehabilitation, did she become a rehabilitated drug addict? Well, it's when we had when we no longer had a reasonable belief that drug use is an ongoing problem. That is a sentence that makes no sense in the practical world, right? When was the day that we no longer had a reasonable belief? Fortunately, in that particular case, that did not become an issue because the judge actually said there was a 6-month window between when she left rehabilitation and was ultimately terminated. The judge said, I don't know what the date was that they no longer had a reasonable belief, but it was sometime before the day she was terminated. Now, fortunately, her use, fortunately for us, not for her, of course, her use caused restrictions on her license, and the court said we weren't obligated to accommodate her license restrictions, and that's ultimately what ended up in the dismissal of the case. But I think it's important to note that at some level, when we were dealing with that individual, she transitioned from not disabled to disabled at a time that no one could ever define. Important to keep in mind as you're dealing with those issues. You're entitled to the same protections once you fall into that category of disabled as any other employee, and we're obligated to go through the interactive process as with any other employee. Of course, we can have policies that allow for drug testing. We don't have to reduce our expectations based on someone's illegal drug use or alcoholism. You know, if an alcoholic came in and said, hey, you know, I'm an alcoholic, so sometimes it's hard for me to get here at 8 o'clock in the morning, that's not something that we would have to accommodate in that context. We also don't have to tolerate poor job performance that's the result of that. FMLA and the ADA, actually, well, maybe not the ADA. Let me take that back. The ADA for alcoholics, not for drug addicts, and the FMLA for both, would obligate you to give employees leave to attend rehabilitation facilities. So if you're covered by the FMLA and you have an employee that requests time off to go to drug or alcohol rehabilitation, that is something that you would have to give them as an accommodation, or as a matter of law under the FMLA. The ADA would say you have to accommodate the alcoholic in that context, the current illegal drug user, not so much. But do you really want to be the school that didn't let them go to rehab? From a policy perspective, we should make sure that we have policies that allow for drug testing on reasonable suspicion, and that delineate what will be the result if employees are found to have engaged in illegal drug use or found to have been intoxicated at work. think that was the last real slide. This is a general, this is everything we've learned today. The one bullet point that I really want to highlight, because I see this a lot, is the don't pretend to be a doctor. I can't tell you how many times I get calls from clients and the person says, well, you know, my cousin had depression, and when he had depression, you know, he didn't need to do this, so I don't think that this is legitimate. And it's like, that's not how this works. Like, imagine I go into court and say, well, her cousin didn't have to do this, so we denied the request. You know, you have to really go by what the doctor is saying in the forms. You know, absent some evidence that what's been said is incorrect, wrong, or untrue, you need to rely on the medical professionals to be telling you that. So we have 3 other topics. Oh, yes.
So, say someone has this medically, I don't know where Pennsylvania stands right now, but medical marijuana use for somebody's vaping in their car at lunchtime and then needs to come back in and teach.
Yeah.
Medical clearance.
You don't have to let them do that. Because you don't have to let your employees be high or drunk at work. Just like I have a legal right to go drink as many beers as I want following this presentation, I did not have a legal right to drink as many beers as I wanted before. That doesn't matter. You don't have to let someone be intoxicated at work. And that's the same thing with respect to the case I was telling you about where the person was using oxycodone and oxymorphone. In that context, let's say that those were prescribed for legitimate health conditions. They weren't.
Disease that they're dealing with anxiety and estimate issues, and that's what they need.
Yeah, the accommodation in that context is not allowing them to teach class high. It is either providing leave, transferring to a different position, or if they cannot perform the job without having to use medical marijuana or other mood-altering drugs, you know, terminate. That would be the ultimate result. But again, you don't have to let someone come to work or school high, drunk, or on opiates simply because they have the prescription for them. You're allowed to set standards for behavior at work. Then you would go through the accommodations analysis that we discussed earlier to determine, are there other ways that we can accommodate their need to medicate? You know, so like if you had a truck driver that pulled his back out, you don't let him drive the truck on Percocet, you give him the 6 weeks off that he needs to recover.
So that's something on like a Prozac or Xanax or anything?
Well, that's different. Those are not narcotic medications, so they wouldn't be things where you would be taking them and seeming inebriated. Those, you know, those are antidepressants, so you would actually want your employees to be taking those before them.
But a lot of times you don't even know they're high. That's the hard thing. You don't really know. You know what I mean? Like it was just say by chance somebody saw this, you didn't even know they had a medical thing. And they don't even seem high, but it's what keeps them from leaving. That like it just keeps their nerves. And if they're not being from a teaching standpoint, not preventing them from teaching, but it's just from the standpoint I wasn't clear if this is like as a prescription like a Xanax. I don't know enough about.
No, you would treat a prescription that's an antidepressant, which is a non-narcotic medication, much differently than you would treat narcotics in the way that you would accommodate them. Because using narcotics or marijuana have different side effects that could impact someone's performance at work. You know, you have a truck driver that's using Prozac, there's no problem with that. You know, you in fact want that to be the case, right? If he's using Percocet, you know, whatever, up through marijuana, you don't have to accommodate that by allowing him to drive on it. That's why, so if you see the teacher using it in the car, you would send them for the drug test that you are allowed to do under the law and pursuant to your policy. When it came back positive, you would say, and he said, I had a prescription, you know, we could do a bunch of other things, but the nicest thing to do would be to say, you cannot use that while you're at school. Frankly, that's probably against federal law. You cannot use that while you're at school, which means you either need to not do that before you teach, or we need to figure out another way to accommodate you if possible.
This is really an evolving area, though. So really try to, check in with us if you have an issue with that, because
Especially
I have
with
to
marijuana, yeah.
Yeah, because I mean, I think we'd be having a little bit different discussion if it was New Jersey, and I think we're just seeing different laws being implemented. So just be careful with that. If you're going to take an adverse employment action against someone, just give us a call, because I really think that the perception of marijuana is changing, and it may be something that eventually we do let people do, just like you're saying, like we let them take Percocet, we let them, for medical purposes. Yes.
I have a question about where the drug test will be administered, because it's not something that we do for the adults. We do it for the students, but not for the adult population, so that the kids would have medical health center. Is that something we do with the adult population? Would have to go to like a Quest or?
Send them to the health center?
The students get kids tested. If we suspect something.
I don't see any reason why inherently you couldn't send them to the health center, assuming it's staffed by appropriate medical professionals.
Yeah, like we have a nurse practitioner.
Yeah, I don't see any reason why you couldn't send them to the nurse practitioner on site for the drug test. Your drug testing policies should also have in them, if they don't, consent forms and all that other stuff, so that before they give the sample, they're signing off on consenting to not only giving it, but the location that they're giving it.
I'm not saying you couldn't do it, it's just that you have to watch.
That's more of a problem, I think, in a criminal context than in a civil context. So we've had plenty of cases where on-site facilities have taken drug tests. They're often, hospitals or other medical places where, it's, they have like an occupational medicine person that also does drug tests. The standard for getting that admitted in a civil context is going to be much different than in a criminal context. It's not going to hurt to send them to Quest. And in fact, from a business standpoint, it may be a little easier for, I don't know how big your school is, but the nurse practitioner may be friends with, some of the teachers, or may know them personally. So from a business perspective, it may just be better to send them to a third party. But there's nothing inherently wrong with doing it on site.
I don't have any schools that do it on site, so I've always had them send them to Quest or something like that. But I think Michael's right.
I have a couple
could,
that do them on site, but they tend to be large institutions that have a greater infrastructure. Oh, so any other questions on accommodations? So this is the choose your own adventure portion. We have 3 additional topics we could talk about: compensation issues, social media issues, or child abuse reporting.
And Aggie's going to set up seminars or webinars in the spring. So we'll hit the other 2 topics, so it's not like you're not going to get them, but we have a half hour. So do you want to show hands? Which one?
Can I see a show of hands for compensation issues? Oh my gosh. I was expecting the opposite. Child abuse reporting and social media. We can talk about child abuse reporting after. Alrighty.
The one thing I will just say about child abuse reporting is that there was a case that came out that held a school to be negligent for not having reported abuse. So if you're on the fence about something, it's better to report it to Childline. They can choose not to investigate it, but just so you know, I do think the courts think that that is something that you should err on the side of reporting.
So although I'm surprised that you wanted to talk about the math presentation, it is a particularly relevant one because wage and hour issues are something that I would say in the last 5 to 10 years, we've seen a dramatic increase in the number of claims filed. And that's primarily because, this is a later slide, I think I'm stepping on Susan's toes, but you can file a class or collective action, depending upon where you're filing it, which means you can file a wage and hour claim on behalf of other similarly situated employees. As a plaintiff's attorney, I'm sure you can imagine the draw of that. Your damages aren't just the one person, they're the number of people that you can find that fit within that class. So it tends to be a potentially highly lucrative endeavor for plaintiff's attorneys, which is why we've seen an increase in the number of lawsuits in that regard. Very basic, the FLSA requires that all employees who are non-exempt be paid overtime for work in excess of 40 hours in a work week. And overtime is at least 1.5 times their rate of pay. A work week is a very important definition. A work week is designated by the employer, not by state law. So you can designate your work week in any way that actually benefits you. And that's something that may be worth considering from a school perspective. Most work weeks are 12:01 a.m. on Monday through the end of Sunday night. However, in a school context, you may see a lot of work happening on weekends. So it may actually save you money to designate a work week as, Sunday morning through Saturday night or Saturday morning through Friday night. So keep in mind that you have the ability to designate what the work week is. And if you see an opportunity to change that, we could certainly help walk you through that process, but potentially that could save you money on overtime. Like I said, non-exempt employees are entitled to overtime. Probably the vast majority of us in this room would fall into the exemption category. The exemptions in Pennsylvania are executive, which are heads of school and the like, professional employees, teachers, administrative employees, those are department heads, the head of HR, and then outside sales, which I doubt we have any of those, and then computer employees. And all of them have a list of certain requirements you have to meet in order to be properly classified as exempt. Quite simple. You figure out how many hours were worked over 40 in the work week and you pay them 1.5 times. Very important to keep in mind, you do not pay overtime based on holiday or PTO pay, only on the hours worked. So if an employee worked 39 hours, let's say they worked 10 hours a day, Monday through Thursday, and then took 8 hours of PTO. Even though they worked those 10 hours in the 4 days, they're still only at 40 and not entitled to overtime, even though their check at the end of the week is going to be for 48 hours. In Pennsylvania, because we're running short on time, I won't go through this in great detail, but to say, you can pay hourly employees with a salary. The way you calculate overtime in that context is very complicated, and it's unique to Pennsylvania. So if you have people who are non-exempt, who you are paying salaries, let's talk after, and we'll just make sure that you're calculating that number right. It's called the fluctuating work week calculation. And Pennsylvania law is actually inconsistent with federal law in that regard. An employee is supposed to have supervisor approval before working overtime. The employee works overtime without permission. The supervisor tells the employee that he will not be paid because he did not have permission. Is this permissible? No, we have to pay him if he worked. No matter whether or not he had approval or he didn't have approval. What ultimately happens in that context is this becomes a disciplinary issue, which seems like a counterintuitive result to be paying someone extra money and then disciplining them that you had to pay them extra money. But the law does not allow you to say, well, I didn't tell you you could work, so I'm not paying you for it. That would be a per se violation of wage and hour law, and you would be liable for that. Yes? Still have to pay him. Yes.
Even if it's writing and they sign on one?
Yep. Even if it's notarized. No matter what, if they do it, you pay them for it. Now, if you have an employee who was expressly told not to do it and did it, that's an insubordination disciplinary problem. And that's the appropriate mechanism to address that, is through your disciplinary process. Oh, yes.
And then what do you do with the ones who you don't want reporting, doing more than 40 hours, but not putting in the system?
Well, that's a very significant problem. And the reason for that is it's all well and good until it's not, right? So, oh, I don't mind. And then something goes south and you're getting the claim for all the overtime they work. And it sounds a little different than the reality. It sounds like I told them I was working overtime and they told me not to count it. That is absolutely, again, unacceptable. That is another disciplinary issue.
Do you have time cards in that? Do you have like some kind of mechanism for keeping track of time?
Yeah, we do use an electronic system, but there are people who clock out, then if I know about it, we're gonna address it, but there's some that I haven't wondered.
So if you see someone clock out and go back to work, there should be two things that happen. The first is you should figure out how much time they worked after they clocked out and note that so you can pay them for it. And the second is you should make it very clear that if that happens again, there's going to be repercussions under the disciplinary policy. And that's really the only way to handle that. Yes, ma'am. Yeah.
What would be a suggested policy as far as discipline for something that happened?
Well, do you already have like a progressive steps policy where you have like a first written, second written, final term? I would just make sure that whatever's delineated in your progressive steps covers that, whether it's insubordination. We have some employers, you know, especially in like the retail or restaurant context where this tends to be a huge problem, who very explicitly say in their disciplinary policies, you know, working off the clock, failure to appropriately track time. That's explicitly set forth in, you know, like the list of infractions that can lead to discipline. You could do that explicitly, or you could simply look and say, all right, it says insubordination. You working off the clock when I told you not to is insubordination. You know, you would just want to document in the disciplinary document, you know, first written warning for insubordination, employee was instructed not to work over 40 hours and did so without approval.
Now, I'm just going to express a little bit of a different view because I hate progressive discipline policies. I feel like we never follow them right, and then it's you guys are kind of on trial. Did you do it? Did you do the first one right? So I'd rather you just say overtime is not permitted unless unless authorized in writing by your supervisor. Failure to follow this policy will result in discipline up to and including termination. And I would keep it really simple because I would want you to have a lot of latitude to say, you know what, you did it again, you're fired. There's not going to be much wrong with that because it's not an impermissible reason for termination. Michael deals with bigger institutions who have more, departments who make sure those progressive discipline policies are followed properly. But I hate them for our smaller schools because,
Yeah, that puts a lot of burden on you to make sure you did the coaching and you did the first and you did the second. And
Just years ago, and it may have changed, wasn't there something where it was based upon pay cycle? So if they were paid bi-weekly and they worked 30 hours one week and 50 hours another week, the total is almost just less than 80, or no, it's 40 hours?
40 hours in a work week.
Okay.
And remember that work week word is an important definition. You need to make sure you've got your work week designated and are following that, but it's 40 hours in a work week. So if you could work 80 in one and 0 in the other, and you're getting paid overtime on 40.
and keep in mind, you can change their hours. So like we get a lot of this in like the admissions context where you're doing events and you might have something Thursday night. You can say to your admissions people like, hey, come in late on Thursday because we know you're going to be working late that night. So you can kind of manage it, but that's where they have to be telling you they're accurate schedules.
Yeah, and that's the obligation that falls on the managers, right, is to make sure that they're tracking that and saying, oh, go home early. Oh, you need to leave at 3 o'clock on Friday because you stayed 2 hours late on Tuesday or whatever the case may be.
So that admissions example you gave, that would only be if they were hourly, correct?
Yes.
Yeah.
So all of what we've talked about is only for our non-exempt employees.
But I'm just going to tell you, and we've beaten this to death in prior presentations, like most of us probably have those exemptions wrong. And what we found when we did these topics is we would tell you what the right exemptions should be and how most of your employees should not be exempt. And we really could not get buy-in from heads to change those things.
And the main reason was just that employees felt insulted that we were saying you're really, non-exempt. And so I just want to warn you that like you probably have people who are hourly or who are not hourly who should be. So just keep that in mind. And the way these things come up is so frustrating because you terminate someone for poor performance, they go to a lawyer and they say, oh, by the way, I was wrongfully terminated, and for the last 2 years I frequently worked overtime. And they told me to not write it down, and I'm owed 2 years of overtime and attorneys, So I would tend to, unless you're sure and you've vetted it, I would tend to pay for overtime or manage it.
Wait, did I do this one? Yeah.
So this is another hypothetical. So Kelly, one of your non-exempt employees, often works from home. She finds it helpful to check her email at night to catch up for the next day and plan around what she's going to be doing. It really helps her to hit the ground running and do a better job. Could this be a problem? Any thoughts on? Okay, it sounds like you guys are on top of this. So how are you guys handling this? Because this is actually one of the biggest problems we see, because unless you restrict your employees from accessing their email, and how many of you do that?
We do.
Yeah. Like, how many of you say, like, your teachers or your administrators can't access their work email out of, so none of them can access it from home?
Everybody can.
They can, okay. So just be aware that you're kind of, a little bit open to liability there, because they could then say someday, hey, every night I would go home and spend 15 minutes going through my email because I couldn't do it during the day, and I never counted that. Or they're going to probably say, you told me not to count it. So that is still work. So that's one of the negatives we're seeing to flexibility and technology. Everybody checks their email, and that counts as work. So what a lot of employers are doing is saying, preventing employees from getting onto their work email accounts outside of the office, outside of the school. You want to think about that, or what?
How do they do that?
Most systems just have a mechanism by which you can log in remotely. So for instance, my
But the
dad.
prevention, how do you prevent people?
Oh, your IT department
Your IT
should be able
department.
to restrict access.
Yeah.
So for instance, at our law firm, our non-exempt employees cannot access our email systems remotely unless they're specifically given access for a particular reason. So our I don't know how it works, but I just assume IT walks into a room and like flicks a switch on. I'm sure that's not how it works, but that's how I envision it.
But they definitely can set that up, and that's what employers are switching to, is saying, look, you have a work email account, and we're restricting your ability to even access it outside of, your school technology. It's not the only way to do it, but just keep in mind that that's an area of exposure. So if you're going to let them have access, you want to be having time cards that they sign off on. And even that's not bulletproof. It's going to give you, a defense at the end of the day, where it's going to be, well, she says she worked overtime. We have all these time cards she signed off on that she didn't include that in. Now, then you want to be careful, because if the time cards are 9 to 5 every day for the last year, it's going to look like it's not accurate.
They'll be able to get access to documentation from the email system, and if they see emails being sent at 8:59 p.m., we all know what that means. My mother used to be the receptionist at the health center at the Mercersburg Academy. I probably shouldn't have said that part, but oh well. And she would come home and read emails from home, and every single time I would say, you're not supposed to be doing that. And she said, oh, I just need to get this done. And her manager never once told her not to do that, and it drove me crazy, because I'm sitting there saying, you're not supposed to be doing that. And that's exactly how people figure this out, is they have snot-nosed attorney kids watching them doing it and saying, you're not supposed to be doing that. And things go south, what's the first thing I would have told her? Oh, no, I've got an attorney in Philadelphia you're going to be talking to.
Well, and it is one of the often things that the attorney will throw in. So we often see we fired someone, they say we fired them because of age. When we get the complaint, this is thrown in there. So that's often how it comes up. Yes?
Is it possible to document, like in the, I guess, the job description, that emails should only be looked at during the workday?
Sure, absolutely.
Would that, like, cover us?
No. See, unfortunately, if they work it, you've got to pay them for it, which I know seems so unfair. You can have all these policies and make it in writing, but if they work it, the law says they have to be paid for it.
The job description is going to be useful in the discipline context. Look, we told you this, you did it anyway, here's your discipline. but it's not going to be useful in terms of demonstrating either that we don't have to pay them or that they didn't actually do the work.
Where do teachers fall into this?
They're exempt.
Yeah.
Most of your teachers are going to be exempt.
They have to actually be teaching. That's a little caveat there. So like if you have a coach who's not really teaching tennis, but maybe it's like putting the stuff away, but it's kind of a,
Overtime, can you require them, like say they were working late at night on overtime, can you require them not to come in on Friday?
Yeah, absolutely.
Do not report.
Yep.
And do not use your name.
okay, so your school, I think we've touched on this, but your school terminates a non-exempt employee. The employee reports the school to the DOL claiming that they regularly worked overtime and were not paid. How will this be resolved? What evidence would make a difference? And so I did have this recently where the employee did report us to the DOL, and they had not been paying overtime properly. So any thoughts, though, on what the DOL is going to have to do and what we're going to do as a school? Yes.
Go back and have them say what they worked and provide like a calendar and times and document what they say.
Yep.
Basically, we had an employee not file a claim, but say in a further discussion on other issues, say that I worked all this overtime and was told not to because of budget reasons. And so we just basically went back, I think, 2 or 3 years and paid everything that they said.
Yep. That's right. Yeah, I mean, there's not much.
We did this for 3 employees.
Yeah, no, and it's very frustrating. And you can go back 2 years, 3 years if it's willful, so that's what you're looking at. What evidence would make a difference? Well, you can try to show the policy that said they were supposed to get it in writing and they didn't, and maybe you have timesheets where they clocked out, but you know, it's definitely going to be a case that, you know.
Key fobs, if you have key fobs that show going in and out of buildings in any way, very useful piece of evidence to have, especially for start times.
Yes.
Or not useful depending upon when they're showing up.
I've heard of some schools using comp time, but that is.
Yes, that is a big no-no. The only people that are allowed to use comp time is the federal government. Yeah. Comp time, for those of you that don't know, is if you say you worked 50 hours this week and I say to you, you only have to work 30 next week. We'll give you comp time next week, so we'll give you those 10 hours off next week. That's not how it works. You still have to pay the overtime for those 50 hours. You can't give them comp time in another work week.
Is it true that if one employee goes to the Department of Labor about an overtime claim, that they can come in and review like all non-exempt, so
Yes.
it creates a bigger issue?
And when you say come in, they will literally come to your workplace and sit in a conference room or at an empty desk and sit there and ask you, can you go get me, I want to see this. And they will stay there for, we've had them go on for weeks at a time.
That's basically why we paid the 3 employees whatever they said. Before we went to the department.
In the case of the way they like to bring it back, and you go back, come back, is it compounded or is it just the base? I don't know if there's interest involved.
I mean, in a lawsuit, if a judgment was entered against the school, interest would be included. That's generally not a discussion if you're resolving it between yourself and the employee, or even if they have an attorney involved. Usually it's just the flat.
You're going to negotiate, once an attorney's involved, you're going to negotiate it, so hopefully you're going to pay less than they're saying they are owed. But like she's saying, there's not a lot of defenses to it, so you end up paying more.
And wage and hour suits are particularly dicey because in order to settle a claim under the FLSA, a judge has to approve the settlement. And the judge will look at the fairness of the settlement. Whereas, you know, if you just filed a discrimination lawsuit, I can settle it with you for $50 and nobody's ever going to know about it or look at it. As long as you sign off on it, great. But wage and hour cases have to be approved by federal judges.
Well, and the other really frustrating thing is the attorneys on the other side get their fees. So we have a case right now where there's 1 week of overtime. So we've been able to get them down to they only arguably worked 1 week, but the attorney will not drop the case because he's getting his attorney's fees. And since we're liable for the 1 week, we're likely to end up paying the attorney's fees. So they're very frustrating cases.
So the plaintiff's gonna get $87,
Yeah.
and the attorney's
He's
gonna
gonna
get
get
$187.
Yeah. How would you classify the head of school's executive secretary?
Definitely not exempt.
And
But they're probably all exempt right now, yeah.
Yeah, I think that's the problem with a lot of
I know.
small schools is they're not systems where they track their hours or they're paid by the hour. They're paid salary, not exempt. And the problem is the HR department doesn't ever know when their boss still expects them to be checking and responding to emails on the weekend. This thing going off all hours of that, I think there's a lot of that that the HR department doesn't ever know. It's almost like, well, we all in this room know what they shall and negotiation, but the managers and the other people, they're actually.
I know.
It's not even on the radar. I guarantee they don't even know what their status is.
Yeah, no, you're absolutely, I mean, you're preaching to the choir. We did so much work on trying to educate people on the exemptions, and I'm sure 95% of your schools should be non-exempt. And it's probably not that way. And we did so many seminars and webinars, but unfortunately, we can't get buy-in from the top. And I think, unfortunately, other industries are seeing lawsuits because they're great lawsuits. But I think you guys are, not you guys, but schools are getting away with it because teachers are exempt. And so most of your staff, you know, like you're not going to be the first target because most of your employees, you know, are because there's a special teacher exemption. So we just feel like eventually someone's going to get hit, and that's when everybody's going to correct it.
Oh,
But
I'm
until
gonna
then,
quit and go be a plaintiff's attorney, coming after all y'all.
really, I mean, I'm sure everybody in this room has them done wrong, and we've spent so much time. Aggie had webinars and seminars, so you're right.
Well, even the terminology outside of HR, they take non-exempt means out. They use the opposite.
And they also just think, well, they're salary, so I don't have to pay them overtime. No, that's not. You can't just pay them a salary and make them exempt. That's not how it works.
And I've seen like people just get the title of director, just because they think that makes them exempt, but they're not supervising them, they're not giving them higher.
No.
That's an excellent point. You know, the law or the state's not just going to say, oh, well, it says chief executive officer, so they might, no, they're going to look at what the person's actually doing to determine whether they're appropriately classified.
Can you explain to me why the secretary is non-exempt?
Sure,
Like,
so,
what's like a key takeaway? Like, I thought it was salary versus hourly.
no, that's only,
Yeah.
the way you pay them doesn't have anything to do with their exemption status. There are 3 primary exemptions that we're looking at that are going to be applicable in the school context. There's the executive exemption, which amongst other things really relates to your head of school. You know, the bigger the organization, you may have a couple other people that fall into that.
But you have to be supervising people for that one.
Then there are the professional employee exemption. That is employees who have gone through a course of study to gain expertise in a particular area of learning and are working in that area. That's what all of your teachers fall under. That's what lawyers fall under, doctors. And then there's the administrative exemption. And that's why it gets kind of tricky, because you think administrative assistant, administrative exemption, done. No, what it really means is it's department heads, people with supervisory authority who manage large aspects of the institution or the company. So business officers, usually heads of HR, people in those types of roles that have discretion to spend significant amounts of money on behalf of the company. So like,
But
if
see,
you're,
hear what he's saying though, because actually even within those, I think very few are actually exempt because you're head of, and you have to be making independent decisions on matters of significance. So that means you're saying your HR person, yeah, hire, fire, do whatever you want. You don't even have to come back to the head of school to get permission. You know, I mean, how many of them are really doing that? So when you look at them independently, they're usually not fitting into that administrative exemption.
Development department, that one always gets.
Yeah, I have to say, I think most of them are not exempt because, again, now if you're saying to your development person, hey, run an event next year and spend $50,000 and just do what you think is best, that would be a matter of significance. But if you're just saying like, hey, try to get donors to give us money and schmooze them as you think best, they're probably not exempt. So that's why I think most of them are wrong. But will we ever change them? Probably not.
Yeah, what are
So-
the legal implications besides if someone sues you?
The federal or the state government could investigate you for overtime violations.
It's overtime that it mostly affects though.
Yes.
Okay.
There are other things like you're supposed to be keeping records and doing
Yeah.
other things, but those are going to be more like fines and penalties. Yeah. Yeah.
There's unpaid taxes, so the IRS could come and say, wait a minute, these people are improperly classified, and had you properly classified them, you would have paid an extra $80,000 in wages, and had you paid an extra $80,000 in wages, you would have given us an extra 10. So we'll take our 10,000. That's when you'll start hearing about interest. The
It seems dire, but we
gets
couldn't get
interest.
anyone to, I mean, the heads just are not focused on this.
No,
So we could not get,
It's
all
budget,
about
so
budget.
Yeah.
it's really budget, because they can't, the schools can't afford it.
to have people working overtime and getting paid for it, yeah.
Yeah, I don't think it's intentionally that they're trying to take money away from it, it's just affordability, lack of resources.
Right.
Ironically, exactly what the laws were put in place to prevent.
Ignorance
Like that is like the
bliss in
stated
their mind, but they
reason.
still don't want to hear it.
Right.
Accountants, where do accountants stand? Who have
They might be-
CPA, I'm sorry?
Yeah, they might be under the professional exemption. I would think that they fit within that, yeah.
As long as they have a 4-year degree?
Well, that's the thing, well.
It doesn't necessarily require a 4-year degree. It requires some advanced course of study. So,
Yeah.
you know, you could become a CPA who's properly classified as exempt without having a tax degree or anything like that. But you would have to demonstrate that there was actually some course of study that you went through in order to get to that level of expertise.
But the staff accountants would be exempt.
Sure, if they're just collecting receivables or collecting tuition and balancing the books, that's probably not an exempt position.
Can a person be considered exempt that works less than 3 hours a week?
Oh, yeah.
Oh, no, that's okay.
Yeah.
As long as they're like in a position where people are reporting to them?
It's more complicated than that, but
And there's a salary requirement. so-
there are salary requirements for some of them. I think they're relatively low.
Yeah, they're low.
Any other questions? Sure.
Okay, so this is really hitting record keeping, which I think we've touched on. You do need to have some type of record keeping situation, and they can be varied. And we're seeing a lot of electronic ones. We have people where when you sign on to your computer, that's your time in and time out. So there are things like that you could use. There are, old time clocks, manual time sheets.
But people could sign in and be doing personal business too. That's
True.
That's a tough call there.
It's another disciplinary issue.
Now it's signing into, the way you usually have it set up is you're signing it into your school computer. So but yeah, if you come in at 9 and start
You could go
online
back
shopping.
to the website, browser history.
Right.
You can see they're reconciling your checkbooks, they're
Yeah.
shopping on Amazon and like that. I mean, I don't know.
Yeah, no, that's true.
Judgment call.
Yeah.
Just because they're there doesn't mean they're.
No, they're working, right.
The head of school's assistant has offered to sit with different classes each day while she eats her lunch to give the teachers a break. Sometimes she eats her lunch and reads a book. Other days she is helping the kids with their lunches. Sometimes she has to finish something, so she continues working during that time. What are the implications of this? She's working. Is she working even if she's at lunch reading a book? So that's exactly right. There's a phrase that I like. It's called engaged to wait or waiting to be engaged. And that's how they draw the distinction between whether you get paid. If you're engaged to wait, then you get paid. If you're waiting to be engaged, then you don't. That comes in handy with on-call people a lot, but that's exactly appropriate in this context. She's clearly engaged to wait. So she's been hired and sent to the lunchroom to wait to see if there are issues. Even if there aren't any issues she's handling at that particular time, that's compensable time. But it is important to keep in mind that employees are not entitled to breaks. and I'm talking about anyone 18 and over at this point, but there's no federal law that guarantees a lunch break. There's no state law that guarantees a lunch break. You can make your employees work as long as you want. You know, they're going to start quitting if it's too long. But there's no obligation to provide an adult with a break under state or federal law. There are some industries where there are, like I think there are some rules specific to agriculture. Probably not applicable here.
Can you require employees to take breaks?
Sure.
I mean, that's one of our biggest issues is that, you know, we have people who, some of our dorm parents who work like 11 hours and they haven't punched out for a break.
Yeah.
And like you have to take a half-hour break. You've got to walk away and take a half-hour break.
You can absolutely make them take breaks.
But
If
there's
they
no
don't and they stay clocked in, obviously you pay them for the time.
There's no certain point where you say legally you have to take a break. They don't have to.
If the break is less than 30 minutes, you pay them for it. If it's over 30 minutes, you don't have to pay them for it. Federal law basically says, oh, a short 5-10 minute break is not something you're going to subtract from their pay, but anything over 30 minutes is appropriate to be subtracted.
So I think that's our time.
It's perfect.
So, I don't know if there are any questions. We'll stay around for a bit, and we'll work with Aggie to, you know, do these another time. Awesome.
Thank you guys for all your awesome questions.
I know. So I just want to thank Susan and Michael for being with us today, and I want to thank you for, there are 27 of you still here, so God bless you. We really appreciate you playing our little game this morning and giving us some feedback about how we can help you better. And we really appreciate all the time that you spend working on behalf of our students. So thank you for being here, and thanks again to Michael and Susan. Yeah.